file 22-21196-FC, People versus Andrew Olmhausen. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Palpable.
Good morning, Your Honor. Melissa Palip on behalf of the people.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Andrew Olhausen. We both appear via Zoom and consent as such. Drew, please state your name for Judge Olslaver, Prosecutor Palip, and the staff to know it is actually you.
Andrew Olmhausen.
And Mr. Amadeo, where do we stand with this case today?
Your Honor, I'm going to give a brief update, and Attorney General Palip, please correct me if I misspoke on anything. At this point, the Attorney General is trying to provide some evidence that allegedly has some CSAM in it, and they're trying to get me a clean copy, which is not an easy task with MSP. I also made about 3 trips to the Adrian Police Department to meet with Detective Keene. On one of those trips, she told me that she actually deleted some evidence by mistake and she would try to revive it. So at this point, I'm still waiting on some evidence. Obviously, when I get the abundance of evidence, I'm going to need to file motions. And I do want to make this clear, Judge, it's no fault of Melissa Palip at all, but I really do need all the evidence to properly advocate for my client. So we're kind of in a holding pattern with that. And Melissa, if I misspoke, please let me know.
Yeah, I just want to clarify on the MSP aspect of it. I did drop off all of the hard drive evidence, which is basically all of the evidence, to MSP because I can't copy it to make them a copy because it is CSAM. So what they're trying to do is scrub it for Mr. Amadeo so that he can have the phone dump without any of the CSAM. But because the CSAM is intertwined with all of the phone dump, she has to go image by image and page by page to try to scrub it out. So it just, with 300,000 plus images, it's proved a little bit difficult. I actually have a call scheduled with her in about 45 minutes to discuss where she's at with all of that.
All right. So I guess I'm hearing that you're going to agree to adjourn this. Is that correct?
Yeah, that would be correct, Judge. And I think,
okay,
if acceptable to you, Your Honor, and AG Palip, I think maybe 45 days to make sure we're not wasting the court's time. I really want to study the evidence, and there has been diligence from the AG to get it, but I really do need it to speak intelligently further on this case, in my opinion.
Ms. Palip, any issue with that?
No, Your Honor, that's fine.
Okay.
I'll prepare a stip, Judge, and send over to Melissa for her approval, and I'll send it to your staff and everything if it's good with her.
All right, so 45 days, the Monday closest to 45 days, the courthouse is closed. So how about June 26th?
That's fine, Judge.
So the only thing I'll say about that week is that I'm in a homicide trial in 3rd Circuit.
Okay.
I'm available the week before, like the weeks before I'm available, and then after I'm available.
Does July 3rd work for the court, Judge?
It does not.
Okay.
I'm not going to be in town. You have to go to July 17th. So we'd be looking at either June 12th or July 17th.
I prefer July 17th. I think it will give us enough time to get on the same page if that works for the people.
Either of those days work for the people, so the 17th is fine.
All right. We'll go with the 17th then. And see where we stand at that point. Perhaps if you have an opportunity, you'll be able to get your motion filed by that time.
Yes, Judge.
Yeah, I mean, I certainly understand. It sounds like there's a ton of evidence to go through. So,
yeah.
All right. Anything else that we need to address for today?
Not from the defense, Your Honor.
Nothing from the people.
All right. So thank you. Then we'll see you back then on July 17th at 8:15 a.m.
Thank you, Judge.
Thank you.
Thank you.
He's not upset though.
Okay, I just have someone here at ARF Hearings. Can you tell me who you are?
I'm here.
Okay, let's see, Mr. Hairston, your attorney is not logged in yet, so I'm going to put you back in the waiting room. As soon as she gets here, I'll bring you back in. Okay, and let's see, Mr. Amadeo, I have Mr. Davis here. Do we have the prosecutor that is handling the Michael Davis case?
It's Alex. I don't know if he's there, but let me shoot him a text real quick.
Mr. Shears is here. Mr. Shears is here. Mr. Shears, do you want to come forward? You can sit at the table here. We have the prosecutor that's handling the Frederick Shears case.
Judge, I'm on Frederick Shears.
All right, we are on the record then in file 24-21752-FH People versus Frederick Shears. We are here today for a pretrial conference in this case. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
May it please the court, George Lyons on behalf of Mr. Shears.
All right, and Mr. Lyons, where do we stand with Mr. Shears' case today?
Your Honor, as I shared with the court, and I think this may have been a snafu of my own, apparently in Illinois, you do have to specifically request a transcript. We're taking care of that this morning, Your Honor. We'd ask for an adjournment while we get that taken care of. Mr. Shears is there live and in person. I think he's been complying with the terms of the court's probation, bond rather.
All right. Yes, I apologize. I did not say Mr. Shears is here present in the courtroom in person. Ms. Arnold, is there anything to address from the people's side?
The only thing I'll put on the record for the benefit of Mr. Shears and Mr. Lyons is there's a federal case that's kind of accompanying this case, and I need to do some follow-up to individuals in that case to see who may potentially be witnesses in this matter. But other than that, I think follow-up on our end is done.
Well, Your Honor, just to address that issue, we've been asking for all of that discovery in the accompanying federal case that is germane to my client's case. We have only received a one-page summary that tells us little or nothing. So certainly they're treating this like a companion case. We have a right to all that discovery.
Yeah, what I gave Mr. Lyons is what we have so far.
Which is darn little, Your Honor. And if we're talking serious cases here, and I've done enough federal work.
I mean, Ms. Arnold's not the prosecutor on the federal case. I can't.
Well, Your Honor, she may have greater access to those files. It does, having done a number of federal criminal cases, I know their files are voluminous, and I can't imagine that they wouldn't allow the APA for the accompanying case in Little County not to have copies and or access to that.
All I can say is we asked for what they had or they would give us, and what we got, we gave to Mr. Lyons. I'll request it again. I don't know the status of the investigation there. If charges have been authorized, I don't know.
I guess we can wait and see, Your Honor. But certainly, if she's waiting to see if she wants to use those witnesses, there must be information that she's anticipating in order to use those witnesses in her case in chief against my client.
All right, what I'll do is adjourn this to June 26th at 8:15 a.m.
Judge, I'm in. Oh, yeah, that's fine.
June 26th. Thank you, Your Honor. At save time. Thank you, Judge.
All right, Mr. Lyons, would you do a stipulation in order for that adjournment?
I will. I'll make a note of that now.
Okay. There was also an outstanding issue, there was an order to show cause in the file related to a bond violation for a positive drug test. It did get a letter from Mr. Coast that indicates that the lab that did the testing had some kind of an issue, and he is going, or would like to dismiss the contempt or the alleged contempt at this point. So I will dismiss that contempt.
Thank you, Judge. Mr. Shears, I'll call you as I finish here.
Okay. All right. So Mr. Shears, your next date then again is June 26th at 8:15 a.m.
Okay, thank you. I can leave.
Yeah, you are free to go. Okay, Mr. Amadeo, are you ready to proceed with Mr. Davis?
Yes, we are, Judge. Thank you.
All right, we are on the record then in file 23-21590-FH, People versus Michael Jason Davis. We are here today for a pretrial in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record. Do we have someone from the prosecutor's office handling Michael Davis?
Judge, I can appear on that matter.
I'm sorry, he had said Mr. Bayanetto, and Mr. Bayanetto is in the waiting room. Let me bring him over.
Okay.
Okay, good morning, Mr. Bayanetto. I understand you're handling the Michael Davis case.
Yes, I apologize. I got stuck in a cops conference downstairs.
No problem. I had actually I just called it. So if you want to place your appearance on the record, we're ready to go.
Alex Bayanetto for the people.
Good morning, Your Honor. William Amadeo, P76194. We have a Michael Davis. We both appear via Zoom and waive any right to be present in person. Mike, please state your name for the prosecutor, judge, and staff to know it's actually you on Zoom.
Michael Jason Davis.
Okay, and Mr. Amadeo, where do we stand with Mr. Davis's case today?
Your Honor, and Alex, if I get this incorrect, please let me know, but we did send over a police report for a no contest plea. My client will plead no contest, guilty as charged to the 2 felonious assaults under a delayed. If he's successful on 1 year of probation, they will both become aggravated assaults. A domestic violence case that was a trail case and is also being dismissed. And there's a sentence agreement of a jail cap of no more than 30 days. I believe that's everything. And the purpose of the no contest plea is civil litigation, Judge.
All right, Mr. Bayanetto, is that a complete and accurate statement of the plea?
It is, Your Honor, yes.
And I'm sorry, was that to 1 count or both counts?
Both
counts.
counts.
Okay. Mr. Davis, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Michael Jason Davis, correct?
Yes.
Mr. Davis, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention to plead no contests today to count 1, assault with a dangerous weapon?
Yes.
You understand the maximum possible penalty for that offense is 4 years in prison and or a $2,000 fine?
Yes.
Is it also your intention to plead no contest to count 2, a second count of assault with a dangerous weapon?
Yes.
And you understand that carries the same maximum possible penalty of 4 years in prison and/or a $2,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Amadeo and the advice that he's given you?
Yes.
Other than, as we've discussed today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Bayoneto?
That's correct, Your Honor.
Mr. Amadeo?
That's accurate, Judge. Thank you.
Is that also your understanding, Mr. Davis?
Yes.
Guilty plea is accepted. There'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand.
I'm sorry, Your
Yeah,
Honor.
right.
It's a no contest plea. I apologize.
Thank you. I apologize. So if the no contest plea is accepted, there won't be a trial. Again, you'd be giving up any rights that you would have had at trial, and I'm going to explain those rights. You do have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Davis, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
I'm sorry, can you say that again?
Do you understand that any appeal from the conviction and sentence pursuant to your plea would be by an application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about September 17, 2023, in the city of Adrian, County of Lenawee, that you did commit the offense of count 1, assault with a dangerous weapon?
No contest.
And how do you want to plead to the charge that on or about September 17, 2023, again in the city of Adrian, County of Lenawee, that you did commit the offense of count 2, assault with a dangerous weapon?
No contest.
Has anyone made any threats or promises to you to induce you to plead no contest to those charges?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Davis to plead no contest?
No, Your Honor.
No, Your Honor.
Mr. Davis, has your attorney promised you any particular sentence or estimated what your sentence would be, other than as we've discussed it on the record here this morning?
Sorry, can you say that again?
Has your attorney promised you any particular sentence or estimated what your sentence would be, other than as it's been discussed on the record here today?
No, Your Honor.
Is it your own choice to plead no contest today?
Yes.
All right. And how are we establishing the factual basis then?
Your Honor, I believe a police report was sent over by the people yesterday, and we'll stipulate to the elements within that police report.
I don't believe I have any police report that I'm aware of.
Your Honor, I can I can put the factual basis on the record. Reading from Adrian Police Department report number 230009898, authored by Officer William White. Had this matter proceeded to trial, Your Honor, people would have proven that on or about September 17th of 2023 at 418 Clinton Street in the city of Adrian, County of Lenawee, state of Michigan, the defendant, Michael Davis, did commit an assault with a dangerous weapon on an Odessa Seymour and a Jonathan Seymour, Your Honor. The facts surrounding that assault were this. On September 17th of 2023, Jonathan and Odessa Seymour were walking with their child. There was a verbal altercation in front of the defendant's residence. At that time, Mr. and Mrs. Seymour retreated back to their residence, where they were further confronted by Mr. Davis. During that confrontation, Mr. Davis did pepper spray directly into Odessa Seymour's eyes, while Mr. Jonathan Seymour was not affected by that pepper spray. He was standing next to his wife as that happened, which I believe would have made him fearful of an imminent battery. Your Honor, I believe that satisfies the elements for assault, and the dangerous weapon being the pepper spray.
All right, Mr. Amadeo, do you agree that that would satisfy the factual basis for both counts?
I do believe that would satisfy the elements factual basis for both counts, Judge.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Bayonet?
I believe it has, Your Honor, yes.
Yes, you have, Your Honor.
Thank you. I will accept the pleas. Then they have been given understandably, voluntarily, and accurately. Mr. Davis has had full knowledge of his rights, and he has had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, or any of them other than as we discussed on the record here today. I will refer this matter to the probation department for a pre-sentence investigation, and we'll set sentencing for June 7th at 8:15 a.m. Mr. Davis, someone from the Lenawee County Probation Department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, sir.
Your Honor, could I get a breakout room with him?
Yep, give me just 1 second, Mr. Davis. I'm going to put you in a breakout room with Mr. Moore from the probation department so that he can collect your contact information.
Okay.
Mr. Amadeo, do you want to be in that breakout session?
I don't need to be in that one. Thank you, Judge.
Okay. All right. So, Mr. Davis, you can go ahead and log out whenever you're done speaking to Mr. Moore.
Okay.
Thank you, Your Honor. Have a good day.
Thank you. All right, Mr. Fry, I have Mr. Glaze here by Zoom. Are you ready to proceed?
Yes, sure.
Mr. Glazier. Oh, there you go. Do you need to speak with Mr. Blass?
Yes, I do, Your Honor.
Give me 1 moment and I will put you in a breakout room with him.
May I approach you?
Yeah. Okay, we are on the record in file 22-21136-FH, People versus Raymond Joseph Glaze. Oh, I could bring Mr. Glaze into the Zoom.
Good morning.
Okay, good morning, Mr. Glaze. So let me call the case again. We are on the record in file number 22-21136-FH, People versus Raymond Joseph Glaze. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Good morning, Doug Hartung, appearing for the people today.
Good morning, Your Honor. Brian Fry, appearing for Raymond Glaze. Raymond, if you could state your name for the record.
Raymond Glaze.
All right, and Mr. Fry, where do we stand with Mr. Glaze's case today?
Your Honor, I believe we have a resolution to this case. We have discussed it with Your Honor in the past as well, at a bench conference previously. But the resolution, as far as I understand it, is that my client will plead to add count 2 on the amended information, which is false pretenses 1,000 or more, but less than 20,000, which is a 5-year felony. But we will do this under 771.1 delayed sentence. That will be delayed 3 months. If my client has made full restitution payment by sentencing in 3 months, the charge will be changed and reduced to count 3, false pretenses 200 or more but less than 1,000, which is a 1-year misdemeanor. I do have I am holding in my IOLTA account right now $100,000 that I will immediately be providing towards the restitution in this case to the prosecutor's office. And there's also an agreement for no upfront incarceration. I think that is the full agreement.
All right, Mr. Hartung, is that a complete and accurate statement?
It is, Your Honor. I would add that payment will be made either today or tomorrow from Mr. Fry's IOLTA account. I'm going to text him the name of the victims, so we don't put that in the record here today, so he can make that check payable to them directly. He'll deliver it to the prosecutor's office or his assistant. Well, give it to Rochelle Petty. If Rochelle's not there, then I'll receive it and get it to the victims. And that will amount to the majority of the restitution that is owed in this case. We believe there's another sum that's roughly $10,000 that Mr. Glaze hopes to pay before the time of that date that Mr. Fry mentioned. I would add for the record that the court had a bench conference with us and we discussed this in some detail. And we've had to delay this because Mr. Glaze has been in the hospital with some health issues, but he has managed to come up with a balance of $100,000 as the initial down payment.
All right, Mr. Glaze, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Raymond Joseph Glaze, is that right?
I am.
You've heard the statement of your attorney and the prosecuting attorney is that your intention to plead guilty today to count 2 on the amended information, false pretenses $1,000 or more, but less than $20,000.
It is, Your Honor.
You understand that the maximum possible penalty for that offense is 5 years in prison and or a fine that is the greater of $10,000 or 3 times the value of the property or money involved, whichever is greater.
I do, Your Honor.
Are you satisfied with Mr. Fry and the advice that he's given?
I am, Your Honor.
Other than as we've discussed it on the record here this morning, neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court. Is that correct, Mr. Hartung?
It is, Your Honor.
Mr. Fry?
Yes, Your Honor.
Is that also your understanding, Mr. Glaze?
It is.
If a guilty plea is accepted, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial. You can't ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Glaze, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
I do, Your Honor.
Do you also understand that any appeal from your conviction and sentence would be by application for leave to appeal and not by right?
I do, Your Honor.
If you are not a U.S. citizen, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
I do not, Your Honor.
You understand that you're giving those rights up?
I do, Your Honor.
How do you wish to plead then to the charge that on or about March 8, 2021 in my information doesn't have a city, township, or village. Do you know that information?
Would have been in, I believe that would be Britton Township, Your Honor. It's in Raleigh County.
Okay. In Britton Township, Lenawee County, Michigan, that you did commit the offense of false pretenses of $1,000 or more, but less than $20,000.
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of any threats or promises that were not disclosed to the court on the record this morning?
I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Glaze to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Glaze, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it here this morning?
No, Your Honor.
Is it your own choice to enter the plea?
It is, Your Honor.
Mr. Friday, you want to cover the factuals?
Yeah, I can do that, Your Honor. And just to be clear, because I don't think I stated it, it's probably assumed, but the other counts would be dismissed as part of this plea. So, I mean, if the count 2, if he doesn't make the restitution, counts 1 and 3 would be dismissed at sentencing. And if he does make the restitution, counts 1 and 2 would be dismissed at sentencing. So,
that's all I have, Your Honor.
So, how you doing today, Mr. Glaze?
I'm well, thank you.
Okay, so on or about March 8th, 2021, did you enter an agreement with a Kelly Dyke?
I did.
Okay. And did that occur, was that for work to do in Lenawee County, state of Michigan?
It was.
Okay. And were you going to get I think a manufactured home and put it on her property?
A modular home, yes.
Okay, so a modular home, and you were going to set it there?
Yes.
Okay, and did she wire you money to do that job?
Yes.
Okay, and was that, what, over $100,000?
I don't recall the exact amount, but yes.
Okay. Would you agree that it was over $1,000?
Yes.
Okay. So did you use that money to get that modular home for her?
I used the deposit to place the order for the home. And while it wasn't intentional, the rest of the funds were used for operating expenses of the business.
Well, did you intentionally use the rest of the funds for operating expenses for your business? You knew what you were using that money for, right?
For the business, yes.
Okay. So you didn't use it for her job that she paid you to do, right?
Beyond the deposit for the home, no.
Okay. So for your expenses or other business issues, where all that money went?
Yes,
Okay. And that's not what she paid you for, right?
correct.
Okay. And is it fair to say that she expected you to use the money that she paid you for what she hired you to do?
Yes,
Okay. So she relied on you to use that money to carry out the contract that you had signed with her?
she did.
Okay. And you didn't do that, right?
I'm sorry, I didn't hear you.
You didn't do that, is that correct?
Correct.
And would you agree that she suffered a loss because of that?
I would agree.
I believe that satisfies it.
I'm satisfied.
And has the court complied with MTR 6.302 B, C, and D, Mr. Hartman?
Yes, Your Honor.
Mr. Fry?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Glaze has had full knowledge of his rights and he's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, except as has been stated on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation. And if we're looking 3 months out for a sentencing date, we'll be looking at August 1st, would be 3 months from today. August 1st at 8:15 a.m.
Is that what day of the week is that?
That is a Thursday.
Can we do that till next week? I think I'm out. I think I'm away that couple of days.
Yeah, the following Thursday would be August 8th.
Thank you.
That works for me.
All right, so August 8th at 8:15 a.m. Mr. Glaze, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
I will, Your Honor.
All right, Mr. Glaze, I'm going to put you in a breakout session with Mr. Moore from the probation department so he can collect your contact information and give you some instructions about when and where you need to show up.
All right, thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Mr. Dagger Margosian, are you there? Oh, okay. All right, just saw that message. So I'll get to Mr. Crockett next. Let me do Mr. Blass first. Okay, so we're on the record in file 24-21771-FC, People versus Andrew Aaron Blass. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
D.B. McClure on behalf of the people.
John Glazier on behalf of Mr. Blass, Your Honor.
All right, and where do we stand with Mr. Blass's case today?
Your Honor, it's Mr. Blass. There should be an amended information. At least I've got a copy of one And Mr. Blass on that amended information is gonna plead guilty to counts 4 and 5. With the understanding counts 1, 2, and 3 and the habitual offender would be dismissed at the time of sentencing. There's also a Killebrew plea that that his minimum part of his sentence would be 6.5 years, I believe, which is the low end of the guidelines. Miss McClure says, and we don't disagree at this point, that the guidelines are 78 to 130, and I think 78 is 6.5 years, if I'm not mistaken. So it'd be 6.5 to 15 is basically what his sentence would be on the 2 CSC seconds.
All right, Ms. McClure, is that a complete and accurate statement of the plea agreement?
Yes, the only thing I would clarify is that the guidelines on the actual CSC second charges are 43 to 86 months. But the Killebrew is to be sentenced starting at 78 months, which is in line with the guidelines on CSC, on a CSC third.
Yeah,
so I'm guessing the guidelines that come back in the PSI are not going to be 78 to 130, but that the agreement is that his minimum sentence would be 78 months.
That's correct, Your Honor. I didn't state that part. He's actually, the guidelines are for the CSC third, even though he's pleading to a second, but they're the minimum
Correct.
of the guidelines on the third.
All right. All right, Mr. Blass, will you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Your Honor.
And you are Andrew Aaron Blass?
Yeah.
Mr. Blass, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 4 on the amended information, second-degree criminal sexual conduct?
Yes, it is.
Do you understand that the maximum possible penalty for that offense is 15 years in prison?
Yeah.
Is it also your intention to plead guilty today to count 5 on the amended information, which is another count of second-degree criminal sexual conduct?
Yes, Your Honor.
And you understand that that also has a maximum possible penalty of 15 years in prison?
Yes, I do, Your Honor.
All right, and you understand that that would also require registration under the Sex Offender Registration Act?
I do.
Are you satisfied with Mr. Glazier and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Glazier?
That's correct, Your Honor.
Is that also your understanding, Mr. Blass?
Yeah.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you right now to make sure that you understand them. You do have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until your guilt is proven beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and to have the witnesses against you appear at trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Blass, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
I understand, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right. I'm sorry, the microphone did not catch your voice that time.
I do, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Again, do you understand that by entering the plea to these offenses, you will be required to register under the Michigan Sex Offender Registration Act?
I do understand, Your Honor.
I'm sorry, I wasn't able to understand your answer.
I do understand that, Your Honor.
All right. Do you have any questions about any of the rights that I've described to you?
Sir.
Do you understand that you're giving those rights up?
Yes, I do.
How do you wish to plead to the charge that on or about January 3rd, 2000, so September 1st, 2023 through January 3rd, 2024 in the city of Adrian, county of Lenawee, that you did commit the offense of count 4, second-degree criminal sexual conduct?
Guilty.
I'm sorry, I wasn't able to understand that.
Guilty, Your Honor. Sorry.
And how do you wish to plead to the charge again from September 1st, 2023 to January 3rd, 2024 in the city of Adrian, county of Lenawee, that you did commit the offense of count 5, second-degree criminal sexual conduct?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept those pleas, you're giving up the right, you're giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas?
I understand that, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Blast to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Blast, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Sorry, the microphone didn't catch your voice.
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, it is.
All right, Mr. Blazer, do you want to cover the factual basis?
Yeah, I can do that, Your Honor. Mr. Blass, on January 3rd of this year, you were living with a Renee Henning. That was that your girlfriend at the time?
I did stay the night there with her, but yes.
Okay. And that night, were you in bed with her daughter?
Yes.
And she's under the age of 13, is that correct?
That's correct.
And while you were in bed with her, was there a situation where you were found with your shorts and your pajama bottoms down, and she had her legs around you, and you were humping or making sexual type motions? Is that correct?
That's correct.
And during that time, there would have been an actual touching of the girl in the vaginal area with your body. Is that correct?
That's correct.
And that was done for sexual gratification as well. Is that true?
I was, yes.
All right. And when this girl was interviewed, she said this had happened before, this same type of incident. Is that correct?
According to the statement, yeah.
What? Excuse me?
According to the statements, yeah.
And is that true that it had happened before between the dates of 9/1/23 and 1/3/24, sometime in that period?
Yeah.
And this all occurred in Lenawee County, the state of Michigan?
Yes, it did.
I don't have any other questions, Your Honor.
Your Honor, I would just clarify that there are 2 victims in this case, and there's a count for each victim. So I would just ask Mr. Blass, one being one of the children, her initials were SK, the other, her initials was AK, is that correct?
That's correct.
And would you agree that both girls were taken for medical examination and both presented with injuries to their vaginal areas?
That's correct.
And that would be as a result of sexual contact.
Correct.
I'm satisfied, Judge. Oh, I'm sorry. And both girls are under the age of 13.
That's correct.
Okay. I'm satisfied with the factual basis.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Glazer?
It has, Your Honor.
All right, I will accept the pleas then. They have been given understandably, voluntarily, and accurately. Mr. Blass has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as it's been discussed on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 7th at 8:15 a.m. Mr. Blass, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
All right.
Mr. Moore, do you need anything else from Mr. Blass at this time?
No, Your Honor, we will contact him at the jail. Thank you.
All right. So sentencing then again will be June 7th at 8:15 a.m. Mr. Blass, you can let the officers with you know that you are done with court for today.
All right. Thank you.
Okay, Mr. Crockett, you want to come forward and sit at the table closest to the television? Okay. All right, we are on the record in file 24-21704-FH, People versus Eric Underwood. I'm sorry, I got the wrong one. So, Mr. Underwood, I'm going to put you in a breakout session with Mr. Murphy, if you give me just a moment here. Okay, so we are on the record in file 24-21765-FH, People versus Jude Michael Crockett. We are here today for a pretrial conference in that case, and we are proceeding today by partially by video conference and partially in person. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
E.B. McClure, on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Crockett. Judge, you should have a second file as well.
I'm sorry, there are two. So 24-21765 and 24-21775 are the two files that I have for Mr. Crockett. So Mr. Dagger Margosian, where do we stand with those cases today?
Your Honor, we have reached a resolution with the people on both of these matters. On 21765, Mr. Crockett will be pleading to fleeing and eluding third, as well as a count of resisting and obstructing. The remainder of the information would be dismissed. On 21775, Mr. Crockett would be pleading guilty to one count of R&O, and all under both of the files, it would be under HIDA.
Ms. McClure, is that a complete and accurate statement of the plea agreement?
The only thing I would ask for clarification on is on file ending in 6-5, count 2 is RNO causing injury.
It's charges that he's pleading guilty to the reduced version of regular RNO. Per Mr. Sneed and I, our agreement on 318.
That's the case, I'm gonna need an amended information.
Is Mr. Crockett in jail?
No.
No, Mr. Crockett is here in the court.
Can we put this out a week then to verify that, because that's not what I have in the file?
Judge, respectfully, this seems to happen a decent amount. I'd like to, I don't want to prejudice him. I know it's minimal, but we're here and we're ready to move forward here.
Well, Mr. Dagger Margosian, I can't accept your word for it that there's an agreement with prosecutors saying there isn't or there might not be. So
I understand that. I'm sorry.
Just not something
sorry, the note I have is from April 9th and it says RNO causing injury, not RNO. So I respectfully don't want to change a prosecutor's agreement if, you know, I understand the notes need to be accurate. If it's not, you know, that's an issue we need to discuss, but I'm not going to change based on the notes.
Where is Mr. Sneed today? Is he in Judge Angelone's court?
He is.
All right, she's got a trial starting at 10:30, so I guess I'll offer the option to Mr. Crockett, if you want to stay till 10:30 and we can get Mr. Sneed here to deal with this issue directly. We can try to do that, or I can adjourn this a week and we can can't do it. We'd have to do it. Next opportunity is May 22nd, because I'm in a conference next Wednesday and in trial following Wednesday. So we'd be looking at a 3-week wait till we get this resolved.
I can wait.
Sorry?
I can wait till 10.
Okay. All right. If you want to just have a seat then back where you were, we'll wait till we get Mr. Sneed here and get that issue resolved. Mr. Harrison, are you there?
Yes.
Okay, Mr. Harrison, I'm going to put you in a breakout session with Ms. Underwood.
All right.
Thank you, Your Honor.
Mr. Glazer, do you need to speak to Mr. Johnson? You're muted there.
Yes, I do, Your Honor.
All right, 1 second.
Looks like you have to remove it more. Could we get Bobby Brown in the room, please? Thank you. Bye.
Okay, Mr. Glazer, are you ready to proceed with Mr. Johnson?
Yes, I am, Your Honor.
Okay, we are on the record in file 24-21743-FC, People versus Darren William Johnson. We are here today for a pretrial hearing in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record. Do we have someone from the prosecutor's office handle this case?
It should be Miss Wagner. I see her on there. I don't know if she knows.
Hi, Judge. I'm sorry.
So you want to place your appearance on the record for Mr. Johnson's case?
Yes, Amanda Wagner for the people.
John Glazer on behalf of Mr. Johnson.
All right, and Mr. Glazer, where do we stand with Mr. Johnson's case today?
Your Honor, this matter was adjourned from March 6th. There's a couple of things that we're doing. Number one, we need to set it for an evidentiary hearing, which I assume will probably take at least a couple hours, if not a half a day, but at least a couple hours. So we need to get a evidentiary hearing date, and I'll have a motion filed. It's basically dealing with suppressing some statements and maybe suppressing the evidence as well. And I've got one of the people in my office is doing some research and it's not quite done yet. The other thing is, even after that, there's some issue about a forensic. It's nothing that Mr. Johnson has required, but it's one that some of his family members have said I might want to do or might need to do. But I think I'd rather do the evidentiary hearing first before I request a forensic on criminal responsibility.
All right, Ms. Wagner, anything we need to address from the people's side at this point?
Yes, Judge. So at the last pretrial, Mr. Glazer asked for a lengthy adjournment. It was adjourned over my objection for almost 2 months. Mr. Glazer said that he would be filing a motion to suppress. I talked to him, it's been almost 2 weeks ago, to remind him about that, and I was left with the impression that nothing really had been done up to that point. I haven't seen any motion to suppress, and I was expecting that to be filed by today. So I would just ask that there be a deadline imposed for him to file that motion, and that I be given sufficient time to respond after that, just so we can get this moving, I guess.
All right, so Mr. Glazer, you said, I'm sorry, you need 2 hours for your hearing?
I'm thinking at least 2 hours. Yes, Your Honor.
All right, Francis, can you find us a 2-hour hearing time?
Tuesday, June 11th at 10 a.m.
Judge, that's a state day for me, so I'll be in district court the whole day.
Would you like that backed up to anything, Judge? It'd be a day 4 of a jury trial on June 28th.
What trial?
Jonathan Gregory.
I'm sorry, on June 28th.
Yes,
At what time?
9 a.m.
All right, so let's set it for June 28th at 9 a.m. And I'm going to require that the motion be filed by June 7th. And we'll set it for a pretrial on the same date. So Mr. Glazer, obviously we'll need you to file the motion and notice a hearing for that date.
I will, Your Honor. I just would indicate, Your Honor, I don't like it when a prosecutor gets on the record and starts saying about work that
Mr. Glazer, I'm going to interrupt because I don't have time for this. If you have issues you want to address with Ms. Wagner, do it on someone else's time. I've got too many files today.
I don't like that being done, Your Honor. I think it's a terrible thing.
Mr. Glazer, I'm going to put you in the waiting room because I'm not dealing with this today. Mr. Johnson, you can let the officer that's with you know that you're done with court for today.
Yes, sir. Thank you.
Thank you, Your Honor.
Mr. Murphy, are you ready to proceed with Mr. Underwood?
Yes, Your Honor.
Your Honor, may I trouble you for just a moment? Were we waiting for something, Mr. Vinton?
I don't believe I have Ms. Wise, and Mr. Fenton is not logged. Oh, I'm sorry, he's in the jail. I need to call for him, so we can call for him. But I don't have Ms. Wise for that case.
Judge, Miss Wise is in the Warner prelim downstairs, so she's not going to be present today. So I'm handling that for her, as well as the Winsett and Silvertooth matters.
Your Honor, I would only ask that if it's possible, we put him over for a week. I may be able to show up in person then. I'm having a little trouble sitting up much longer.
Yeah, and I would have no issue with that, obviously, because Miss Wise isn't here this week either.
I don't have, I'm not going to be here next week. The week after that, I've got as many scheduled as I can have because I've got a trial that morning, so it would be May 22nd.
That works for me, Judge.
Okay.
All right. Would you do a stip in order then, please?
Actually, you know what, Judge? I may be in trial that day. But you know what, Your Honor? Respectfully, let me keep that day because that's a bench trial I'm having here, and I'm sure the judge will allow me to come in here and do this. This shouldn't be a very long hearing.
Do you want to do
Okay.
this in order to adjourn, Mr. Lyons?
Yeah, I'm doing one already for Mr. Shears of in for a penny, in for a pound.
You can sign Miss Wise's name to that with permission.
All right, thank you.
Yep.
That was for 5/22, correct, Your Honor?
Correct.
Thank you, Your Honor. Guys, have a great day.
Judge, I did just email on Jude Crockett. I have prepared an amended information, was able to confirm that plea if you do want to go back to that case or when you want to go back to that case.
All right. Once I get that amended information, we'll get back to you. Okay, so we're on the record in file 24-21704-FH People versus Eric Underwood. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Bayanetto.
Morning, Your Honor. Alex Bayanetto for the people.
Matthew Murphy, appearing on behalf of Mr. Underwood.
Okay, and Mr. Murphy, where do we stand with Mr. Underwood's case today?
Your Honor, at this time, the people are offering for Mr. Underwood to plead no contest to the CSC fourth as charged with a killable agreement to no upfront jail. At this time, Mr. Underwood does not wish to accept that. I think we want to set a trial on the matter, but in speaking with the people, I'm not sure if they want to try to amend their information. If they were going to amend their information, that might result in us requesting a possible remand for a prelim. So I didn't know if the court wanted to set a pretrial and then set trial, or if we should just set trial now and see how things fall before the trial date.
All right, so Mr. Bayanetto, are you going to be amending your information?
Potentially, Your Honor. I'd like to talk to the victim one more time before we make our decision on that. I think perhaps it's better just to get a trial date on the books, and then if we do that, then we can cross that bridge when we come to it. But I think for now, getting a trial date on the books makes the most sense.
Well, I would disagree. I have a very challenging docket right now, and I need to have a better sense of whether we're actually doing this or whether we're just putting it there as a space holder, because it's it's just too booked up right now. So,
Your Honor, if you grant maybe just a brief adjournment, and I'll make a decision and we can go from there.
We would have no objection to an adjournment to have this issue worked out before setting a trial date, Your Honor.
all right, let's do May 22nd at 8:15.
I'm sorry, Your Honor, I didn't hear that date.
May 22nd.
Thank you, Your Honor.
All right, Mr. Bayanetto, would you do that stipend work, please?
Yes, Your Honor.
Yeah, but they can't be the same. Okay, Mr. Underwood, you can go ahead and log out. Your next date again is May 22nd at 8:15. You'll log in with all the same Zoom information that you used today.
Yes, sir. Thank you, Your Honor.
Thank you, Mr. Underwood. My staff will contact you about scheduling an appointment, okay?
Yes, sir.
Thank you.
Okay, Mr. Crockett, you want to come back forward? All right, we are back on the record in files 24-21765-FH and 24-21775-FH, People versus Jude Michael Crockett. I do now have an amended information on the file ending in 6-5 that includes a count 4, which is police officer assaulting, resisting, obstructing. It's my understanding that the issue has been worked out at this point. Is that correct, Ms. McClure?
That is.
Okay. Anything else to address at this point, Mr. Dagger-Margosi?
No, again.
Mr. Crockett, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Jude Michael Crockett?
Yes.
Mr. Crockett, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in the file 24-21765-FH to police assaulting, resisting, obstructing a police officer?
Yes.
You understand the maximum possible penalty for that offense is up to 4 years in prison and or a $5,000 fine?
Yes.
Is it also your intention to plead guilty in that file to count 1, which was 3rd-degree fleeing and eluding a police officer?
Yes.
Do you understand that the maximum possible penalty for that offense is 5 years in prison and or a $5,000 fine?
Yes.
Do you understand that that also comes with a mandatory suspension of your driver's license by the Secretary of State?
Yes.
Is it your intention in file 24-21775-FH to plead to assaulting, resisting, obstructing police officer?
Yes.
And you understand again with that charge, the maximum possible penalty is up to 2 years in prison.
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it here today. Is that correct, Ms. McClure?
That's correct.
Mr. Dagger-Margosi?
It is, and I just want to reemphasize that these would be under HIDA, but other than that, no other agreements.
All right. Is that also your understanding, Mr. Crockett?
Yes.
If a guilty plea is accepted, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial. If the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Crockett, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by an application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
None.
And do you understand that you're giving those rights up?
Yes.
How do you wish to plead in file 24-21765-FH to the charge that on or about May 2nd, 2024 in Madison Township, Lenawee County, Michigan, that you did commit the offense of 3rd-degree fleeing police officer?
Guilty.
And how do you wish to plead in that file to the charge that on or about May 2nd, 2024 in Madison Township, Lenawee County, Michigan, you did commit the offense of assaulting, resisting, or obstructing a police officer?
Guilty.
And in file 24-21775-FH, how do you wish to plead to the charge that on or about October 28, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of assaulting, resisting, or obstructing a police officer?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
You understand that if I accept your plea, you're giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than this plea bargain to induce Mr. Crockett to plead guilty?
None, Your Honor.
Okay.
Mr. Crockett, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it here today? Is it your own choice to plead guilty? All right, Mr. Dagger-Margosi, do you want to cover the factual basis?
Your Honor, on 765, I just want to correct the date of offense. It would be March 2nd of this year, not May 2nd. But
okay, I apologize. It does say March 2nd on the information. I must have just misread it.
If I may proceed, Your Honor.
Yep, go ahead.
Mr. Crockett, on March 2nd of this year, were you in Madison Township, County of Lenawee, State of Michigan?
Yes.
And on that date, were you operating a motor vehicle?
Yes.
And were you given either a visual or audible sign by a law enforcement officer to stop the vehicle?
Yes.
And that officer being Officer Zent McCloskey?
Yes.
All right. And you disobeyed that officer was in a fully marked patrol vehicle?
Yes.
And you disobeyed that direct request or signal to pull the vehicle over?
Yes.
And you attempted to flee and or elude that officer?
Yes.
The area of where this was, it was a posted speed limit of less than 35 miles or less?
55 on St. Highway.
This was on Sand Creek where it was a 25-mile-per-hour zone, that section?
Yes.
Okay. And subsequent to that fleeing and eluding, there was an encounter with that same officer on foot?
Yes.
And you, again, disobeyed a lawful order from that officer for you to stop or not run away?
Yes.
All right. And again, obviously, you knew that that was a law enforcement officer?
Yes.
Okay. I am satisfied with that case.
I am also satisfied on that case.
If I may proceed to 775, Your Honor.
Yes, go ahead.
Mr. Crockett, on October 28th of last year, 2023, were you in City of Adrian, County of Lenawee, State of Michigan?
Yes.
And did you have an encounter with a law enforcement officer? You'd have no reason to dispute that officer was Brittany Jones?
Yes.
All right. And you knew that at that time that she was a law enforcement officer?
Yes.
And you disobeyed a lawful order of hers?
Yes.
You had no legal right or basis to do that?
Right.
Okay, I'm satisfied.
Ms. McClure, are the people satisfied with the factual basis?
Do you agree that she was attempting to arrest you or lawfully arrest you?
Yes.
Okay, I'm satisfied.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Yes, Your Honor.
Sir, all right, I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Crockett has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 7th at 8:15 a.m. Mr. Crockett, someone from the probation department is going to do a pre-sentence investigation interview with you. When you do that interview, please be truthful about this offense.
Yeah.
All right, so you're free to go now, but you need to step across the hall to the probation department and give them your contact information. They'll have a packet of forms for you to pick up.
Okay.
All right, Ms. Underwood, are you ready to proceed with Mr. Harrison?
Your Honor, is there, there's some sort of problem with Mr. Hairston's camera.
Okay, can we hear him? Mr. Harrison, are you there?
Yeah, I'm here.
Okay.
They just
so
try
there's a problem.
they just try to fix it, right? But they said they probably would have to log out and log back in. But that still wouldn't change. It's probably y'all camera because I can see y'all camera off. Y'all camera off and say 6 by camera.
All right, so we can all hear each other. Is there a reason that we need to have the camera working?
I don't really know better than me. I'm just trying to go through this stuff.
I just think if we're going to take a plea, Your Honor, that sound isn't real good.
Mr. Harrison, can you sit closer to the device that's in the room with you?
Yeah, I'm sitting close to it.
We're getting an echo. It is a little bit difficult to hear. Can you try maybe not speaking so loud, see if that helps?
Yeah, I'm sitting close to it.
All right, I think that is better. So Ms. Underwood, are you ready to proceed?
Yes, thank you, Your Honor. After consultation
All
with...
right, give me a chance to call the case.
Yes, sir.
All right, so we are on the record in file 24-21684-FH People versus Ardell Lee Hairston. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Rhonda Underwood on behalf of Mr. Hairston.
All right, Ms. Underwood, where do we stand with Mr. Hairston's case today?
At this time, Your Honor, Mr. Hairston will be pleading guilty to count 1 of the information, assault on a prison employee, an E-grade 5-year felony. Count 2 and the supplements will be dismissed, Your Honor, and that is the extent of the plea bargain. All right, Mr. Hairston wishes to avail himself of that.
All right, Ms. McClure, is that a complete and accurate statement of the plea?
It is.
All right, Mr. Harrison, will you raise your right hand and let me know when you have it raised, please?
I got it raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Ardell Lee Hairston, is that correct?
Yes.
Mr. Hairston, you've heard the statement of your attorney, and the prosecuting attorney is it your intention to plead guilty today to assault of a prison employee?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $2,500 fine?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Other than as we've discussed on the record today? Is that correct, Ms. McClure?
That's correct.
That's correct, Your Honor.
Is that also your understanding, Mr. Harrison?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Hairston, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
You understand that you're giving those rights up?
Yes.
How do you wish to plead then to the charge that on or about June 2nd, 2023 in Madison Township, Lenawee County, Michigan, that you did commit the offense of assault of a prison employee?
Huh?
I'm sorry, I wasn't able to understand what you said.
What you said?
How do you wish to plead to the charge that on or about June 2nd, 2023 in Madison Township, Lenawee County, Michigan, that you did commit the offense of assault of a prison employee?
Guilty.
All right, and I'm sorry, Ms. Underwood, was he pleading to just one count or both counts?
Count one, Your Honor.
Just count one, okay. Mr. Harrison, has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to the court on the record this morning?
Yes, I agree. Yes.
Do you also understand you're giving up any and all claim that the plea was that it was not your own choice to enter that plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Harrison to plead guilty?
No, Your Honor.
Mr. Harrison, has your attorney promised you any particular sentence or estimated what your sentence would be other than as it's been discussed on the record this morning?
No.
Is it your own choice to enter the plea?
Yes.
All right, Ms. Underwood, do you want to review the factual basis?
Yes, thank you, Your Honor. Mr. Hairston,
Yes.
back on June 2nd of 2023, were you an inmate at the Gus Harrison facility located in Madison Township, Lenawee County, state of Michigan?
Yes.
And were you a lawfully incarcerated inmate at that facility?
Yes.
And at that time, did you come in contact with a CO Blystone?
Yeah. Yes.
And did you, when you were given your food tray, did you throw milk and juice at the officer?
Yes.
And you know that's an assault, correct?
Yes. Yes.
And he gave you no permission to throw those items at him?
No, no, ma'am.
I believe the factual basis has been laid, Your Honor.
Ms. McClure, are the people satisfied with the factual basis?
Just to clarify, Sergeant Blystone, you had thrown orange juice on him, is that correct?
Yes.
And then there was a second CO Gomez.
That's not the incident in count one.
And you threw milk and urine at that CO, is that correct?
Not no urine.
Your
Right,
Honor.
so Ms. McClure, I'm sorry, so he's only pleading count one, so.
Yeah, I understand, but because the sentencing offense is going to be a continuing course of conduct, it is relevant as to the sentencing guidelines as well as to what offense he actually committed. And if he assaulted both officers, it just goes to the guidelines and the
They
fact.
said one, man. Y'all said one.
All right, Mr. Harrison, just let me resolve the issue before you say anything, okay?
Your Honor, he's only pleading to count one.
All right, so if he's pleading to one count, the factual basis for that count has been established. I'm not aware, Ms. McClure, that you're allowed to question Mr. Harrison to establish other issues that you might think relevant to the pre-sentence investigation report. So has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
It has, Your Honor.
All right, I will accept the plea. Then it's been given understandably, voluntarily, and accurately. Mr. Harrison has had full knowledge of his rights and he's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defendant, or anyone acting in the interest of any of them. Other than as it's been discussed on the record this morning, I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 6th at 8:15 a.m.
June 6th, Your Honor?
Correct. Mr. Harrison, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about.
Okay. Thank you.
All right, you can let the officer with you know that you're done with court for today.
All right, thank you. Y'all be safe.
Thank you. Mr. Thompson. Mr. Malero is logged in now, but he's requested to speak to you in a breakout session. So if you'll step out to the hallway, there's an iPad out there and we'll get that set up so you can speak to him. Mr. Daly, are you ready to proceed with Mr. Jensen? Ms. Underwood, do you need to speak to Mr. Brown?
Your Honor, I was just going to ask, either Mr. Johnson or Ms. Page there, because I know Ms. Brunner is here.
Okay, I appreciate that, but I've got Mr. Brown in a jail room right now, so I need to know if you need to speak to Mr. Brown.
Okay. Then, yeah, I just need a brief breakout with Mr. Brown, and then we should be ready to go, Your Honor. It's going to take a while.
We are on record in file 23-21613-FC, People versus Gage Michael Winsett. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
James Daly on behalf of Mr. Winsett.
All right, and let's see, so Mr. Daly, where do we stand with Mr. Winsett's case today?
Well, you're ready. We're ready for trial. We've stipulated to, excuse me, the jury instructions. We're all ready to go. There's nothing to stop us. My only concern is I don't know what co-counsel is going to do as it relates to Mr. Silvertooth. We're ready for trial. I don't know and haven't been able to find out whether or not they're going to ask for an adjournment. That would bring up a whole new set of issues if they were going to ask for a separate trial and ask for an adjournment. We take no position on a separate trial. I think the law is clear that this court has an opportunity for judicial economy to try the cases together. I've got no problems with that. But we are ready to go to trial in 2 weeks, and we are prepared to go to trial and want to go to trial.
All right, Ms. McClure, is there anything to address from the people's side?
Yes, obviously we need to have an answer on Mr. Silvertooth's motion to sever before we know for sure how this case is going to proceed, but we're also ready to go to trial in 2 weeks as to both defendants. And we did receive, would have been Thursday last week, an objection to our notice of intent to use that did not get a hearing date. Or a notice of intent to use other acts under 404B, I'm sorry. And that did not get any sort of hearing date. I did attempt to get that answered. I didn't get to work on it until Monday because I was out Thursday and Friday last week. So I attempted to get that answered for the court before today. And quite frankly, there's quite a bit of law on that type of evidence coming in. So I want to make sure that my answer is comprehensive and that the court has adequate time to review that. So I'm thinking I could get that done today if we could get some sort of motion hearing on that either Thursday or Friday. And then I think all issues would be resolved at that point. I don't know what defense's availability is for motion hearing, but I know the court has limited availability the next week.
Ms. Clark, do we have any available time in the next week or time before the trial for maybe a 20 or 30-minute motion hearing?
Yes, you could do 8 a.m. on Friday, May 10th. Or you could do 1:30 on May 7th.
If it works for defense, I think I'd rather hear that on the 7th just to make sure we have enough time. Because if we wait till the 10th, I mean, that motion or that response is going to be dispositive of certain witnesses coming in. So I think it makes more sense to hear it on the 7th so that we have time to then amend our witness list if needed, which it is amended right now as if that evidence is coming in. So it'd be more so if the court rules against that coming in that we would have to make those adjustments.
May 7th at 1:30, Mr. Hitt.
I'm not available that day, Your Honor, but Ms. Dumont is here with me, and she is co-counsel on this case, and she is prepared to move forward to handle this motion if I can't be.
All right. So we'll set it for a hearing then on May 7th at 1:30 p.m.
And then I'm guessing at that time, then we can also address if there's an answer on the severance.
All right, well, ultimately, we had that was on the docket for last week. We adjourned that to this week. I mean, we're not on Mr. Silvertooth's case, but when I call that, we can address that issue.
Okay, thank you.
Anything else we need to address with Mr. Winsett's case?
No, Your Honor. I would just like, the record should reflect that at one point, Mr. Winstead gave a proffer statement. And he signed an agreement. He knows under which circumstances that statement can be used, which it can't be used. I went over that with him. I don't know whether the proffer statement is going to come in, because I don't know yet whether Mr. Winstead is going to testify. But in any event, I don't believe it's discoverable. I don't know whether we've got a joint trial or a separate trial, but that would be the only thing that I could think of that Mr. Glazer may not have. We'll provide that to him if he has a right to it. But we're ready to go.
If I could address that issue, I didn't know there was a proffered statement already in the prosecutor's possession. I guess it's a little hard for me at this point to decide whether to ask for severance until I've seen what that proffered statement is. I mean,
all right. So let me. Okay, I'm sorry. Go ahead, Mr. Glazer.
Yeah, I was actually at the point today where I was going to ask for a joint trial and not a severed trial, but this kind of throws a monkey wrench into that. I need to know what that proffered statement is and what its potential may be. I just don't have it. I don't know what it is.
All right, I think we can further address that when I'm able to call Mr. Silvertooth's case. Anything else we need to address with respect to Mr. Winsett?
No.
All right.
Nothing on behalf of the people.
All right, so Mr. Winsett, you can let the officer that's with you know that you are done with court for today.
Okay.
And then can you call for Mr. Silver?
Why is that with Carly?
Because John has
You got Carly on the line thing, but
yeah.
okay, I wasn't aware we were doing it that way, and Carly does.
John has been kind of caught the here at that time.
The color cover it down. Okay.
I would put that.
Oh, what's that?
Or maybe I put that on John.
All right, Ms. Underwood, are you ready to proceed with Mr. Brown?
Yes, we are, Your Honor. Thank you. Thank you.
All right, we are on the record then in file 23-21572-FH, 23-21573-FH, 23-21667-FH, and 24-21735-FH. People versus Bobby Jean Brown III. We are here today for a final pretrial in 23-21752 case, pretrial in all other cases. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Arnold for the people.
Allison Arnold for the people.
Rhonda Underwood for Mr. Brown, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Brown's case today?
Your Honor, we have reached a resolution on all Mr. Brown's files that we intend to implement today. Mr. Brown.
Judge, I would prefer that Ms. Underwood there's a written copy of a plea agreement that she was supposed to sign and have her client sign and send to the court. Because this is a complex matter, I think it might be better if the court has a signed plea agreement before the plea is entered.
I have not had the opportunity, I apologize, Your Honor, to get the plea agreement in writing to Mr. Brown. We have discussed it. If the court wants him to have a copy, we can take a few minutes and I can get one to the jail, or I can go over, but I'm prepared to sign a copy today.
I just think before it's signed on his behalf, it should either be read to him or he should have an opportunity to read it.
Okay.
All right, so Ms. Underwood, why don't you try to see if you can fax or email that over to the jail and have them print a copy and give that to Mr. Brown.
Does the court have a copy of the plea agreement, Your Honor?
I do not that I'm aware of anyway.
And Judge, it's our position that we're not going to send a copy of an unsigned agreement to the court anymore. So once it's signed, if Miss Underwood signs on his behalf, she could email it to the court or email it to the court, I guess would be the best.
How about if Miss Arnold wants to prepare a paper copy, I will come right up and sign it and take it right up to the court.
Yeah, it should have the signature of Mr. Brown on it too, or Mr. Brown's, or she should sign it with his permission, but I can print out a copy here and have it available.
Thank you. I'll be right up.
Thanks.
Okay, so we need the first thing we need to do is get a copy over to the jail so that Mr. Brown has an opportunity to read it.
And if someone tells me where to email it, I'm happy to email it to the jail. I just don't know where to send it.
Hang on. One moment.
Isla, you're so quiet and
If the court wants to call another matter, Miss Underwood could also just bring me the email address when she comes up, either way.
Excuse me. Sorry.
Mr. Malero, are you ready to proceed with Mr. Thompson?
I am, Your Honor.
Thompson, you want to come forward and consider the table closest to the television? All right, we are on the record in file 23-21521-FH People versus Landon Mackay Thompson. We're here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
BB McClure on behalf of the people.
Salvatore Malero on behalf of Landon Thompson.
And sir, you're Landon Mackay Thompson?
Yes, sir.
All right, Mr. Thompson is present here in the courtroom. Mr. Malero, where do we stand with Mr. Thompson's case today?
Judge, last we knew, I think we have to do an arraignment, and then I was going to have him screened for drug court. I don't think he's been arraigned on the information as of yet.
Oh, I'm sorry.
That's where we are.
All right, thank you. Does Mr. Thompson, then Mr. Malero, does Mr. Thompson wish to have that information read?
Your Honor, at this time, we would waive the reading of the information, waive any defects of the time and place of service. We would acknowledge, as I believe it's counts 1 through 5. Mr. Thompson would stand mute. We ask court to set a pretrial. We'd also ask court to set a pretrial for the contempt allegation, and probably 30 to 45 days out, I would expect. And so we can get him screened for drug court. That's our request, Judge.
Is or anything to address from the people's side?
I would have nothing to add and would not object to that long of an adjournment as long as he's compliant with his other bond conditions, if there are any, which I believe he has some.
Let's go with June 12th at 8:15 a.m.
Your Honor, given it's my understanding there's new policy, can it be like 8:45 or 9 o'clock or something?
Oh, yeah, that's so. Yeah, we can call that 9 o'clock instead of 8:15 because Mr. Malero does his cases with Judge Anselm for us, so you don't have to show up at 8:15 and wait. So we'll call it 9 o'clock on that.
Thank you, Judge. I'm just trying not to get in trouble.
Okay, anything else we need to address with Mr. Thompson's case?
Not at this time, Judge. Thank you.
No, thank you.
Judge, oh yeah, is the contempt is set out to that date as well?
Yes.
Okay, great. Thank you, Your Honor.
Oh, shit.
All right, for the gentleman that just joined the meeting, can you tell me your name, please? Send your request to unmute. The gentleman looks like a red jacket. You need to unmute your device. Can't hear you, sir. You need to unmute your device. Your microphone is muted. Okay, sir, what's your name?
Stephen Johnson.
All right, 1 second, sir.
I actually been, all right.
Okay, Mr. Johnson, your attorney is working on another case right now. I'm going to put you back in the waiting room. As soon as she's ready for your case, I'll bring you back in.
Okay, sir.
Your Honor, I
Yep.
have signed that and sent it over. It's being sent by the prosecutor's office over to the jail.
Okay, Mr. Brown, have you received a copy of that document yet?
No, sir. I'm still in the Zoom meeting with you guys.
Okay.
I have no report of that yet, sir.
All right. Ms. Underwood, I do have Ms. Page here. Do you need to speak to her while we're waiting?
Yes, thank you, Your Honor.
All right, as soon as she gets her audio connected, I will have you do that. I've got Mr. Johnson here as well. Do you need to speak to him? All right, Ms. Page, are you there?
Yes, I'm here.
All right, if you give me a moment here, I'm going to put you in a breakout session with Ms. Underwood.
Okay.
Yeah, so it's it.
Mr. Glazer, I have not seen Mr. Clark this morning. Do you know anything about him?
Well, let me see. Am I still representing Mr. Clark?
As of yesterday, that's what the PD's office gave us as who was representing him.
Well, hold on. Let me check, Your Honor.
I have nothing in the file that would indicate otherwise.
Could you hold on a second, Your Honor? I'm checking with my, I had a note in here that we were going to try to get off it, but if you hold on a second, I'll look.
Hey, Your Honor. May I use the bathroom? Your Honor.
Yeah, if there's someone there that, yeah, if you go ahead.
Okay. Thank you.
All right, Ms. Underwood, are you ready to proceed with Ms. Page's case?
Thank you, Your Honor. Yes.
All right, we are on the record in file 23-21372-FH People versus Amber Elaine Page. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Ms. Page this morning, Your Honor.
All right, and where do we stand with Ms. Page's case today, Ms. Underwood?
Your Honor, we're very close to a resolution on this matter. I believe Ms. Brenner and I discussed the 2-week adjournment, and we should be able to resolve this matter, Your Honor.
That's correct, Judge.
Okay, I can't do 2 weeks, but I can do May 22nd at 8:50.
Okay.
Thank you, Your Honor.
Thank you, Judge.
Ms. Underwood, would you prepare a stipulation in order, please?
I will do that with Ms. Brenner's permission.
Yes, thank you.
Okay. All right, so Ms. Page will need to log back in on May 22nd at 8:15 a.m.
All right, thank you.
You can go ahead and log out. Thank you. And Ms. Underwood, you need a breakout session with Mr. Johnson.
Just very briefly, just a minute.
All right, as soon as he gets his audio connected, I'll have you speak to him. All right, Mr. Johnson, I'm going to put you in a breakout session with Ms. Underwood. If you give me just a moment here.
Okay. I'm sorry, the window got a glare with the kids are sleeping. Man.
All right, Mr. Glazier, are you ready to proceed with Mr. Silvertooth?
Yes, I am, Your Honor. I don't know if Mike's on here too. Mike's handling this case with me.
Okay, he is not here. Do we need him?
I guess not at this point, Your Honor.
Okay. All right, then we are on the record in file 23-21612-FC, People versus Kenyatta Taiwan Silvertooth. We're here today for a hearing on defendant's motion to sever trial. And we are proceeding, as well as a final pretrial hearing, we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure. Looks like she may have stepped away from her device.
So she had to step away for just a second. I believe she will be back very shortly. I'd handle the case, but I don't have enough familiarity with the motion to do so.
All right, let's pass this for just a minute and we'll do Mr. Johnson's case. So this is file 24-21757-FH, People versus Stephen Jermaine Johnson. We're here today for a pretrial conference in this case and proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning again, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Johnson this morning, Your Honor. Thank you. I've spoken with I'm sorry.
Go ahead.
I've spoken with Ms. Brenner and Mr. Johnson, Your Honor. What I believe would be appropriate. Mr. Johnson is getting his feet back under him after being incarcerated, Your Honor, but he did pay his bond. So the prosecutor and I have discussed, Your Honor, a 60-day adjournment to allow Mr. Johnson to get regular employment and start making payments, Your Honor, in this matter.
That's correct, Your Honor.
I'm sorry, how long was that?
60 days.
Your Honor.
Okay. Let's go with July 17th at 8:15 a.m.
Thank you, Your Honor.
And I will prepare the stipulation and order with Ms. Brenner's permission.
Yes, thank you.
Okay, thank you. So, Mr. Johnson, your next date is July 17th at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
You can go ahead and log out. Thank you. All right, Mr. Brown, have you received that document yet?
No, sir. Your Honor, would you like me to go check? Because I think they forgot that I was in here.
Okay, yeah, if you wouldn't mind checking on that, I would appreciate it.
Yes, Your Honor. Not yet, Your Honor. Still working on it, I guess. I don't know.
All right, I have someone here whose device is just labeled Motorola Moto G5G. Can you tell me your name?
William Storch.
Okay, Mr. Storch, we're waiting for Mr. Dagger Margosian. He's handling cases with Judge Anzalone right now, so.
All right, well, my network kicked off for some reason. Sorry about that.
Okay, no problem. If it happens, just try to log back in.
All right.
Okay, the gentleman just sat down in jail, Zoom 1. Are you Mr. Kennedy?
Yeah.
Ms. Hennigan, you need a breakout session with Mr. Kennedy?
Your Honor, I will need one, but I need to speak with a prosecutor on this case first because he's got new charges that I'm not familiar with.
I have the new charges, I think.
Can I have a breakout room with Mr. Glazier real quick, please?
Give me just a second. Mr. Dagger Margosian, Mr. Storch is here. Do you need a breakout session with him?
No, Your Honor, thank you.
Oh, you know what? I'm not sure we have. Do we have the right prosecutor at the moment?
Yeah, that would be Mr. Sneed, so I can handle that.
Okay, so we're on the record then in file 24-21797-FH, People versus William Earl Storch. We are here today for a pretrial hearing in this case and proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr.
All right, and Mr. Dagger Margosian, where do we stand with this case today?
Your Honor, we are ready to enter a plea on this case. I can outline it for the court. The plea is that Mr. Storch would be pleading guilty to receiving and concealing 200 stolen property with a value of between 200 and 1,000. A second count of illegal entry. In exchange for that, the original information would be dismissed, the habituals would be dismissed. There is an agreement to pay the full restitution. It may be joint and several depending on the status of the co-defendant cases, but we have agreed that the amount of restitution would be $1,500. And lastly, if that amount is paid at the time of sentencing, there would be an agreement for no upfront jail.
Bring it out.
Okay. Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is.
All right, Mr. Storch, will you raise your right hand? Let me know when you have it raised, please.
Yes, sir.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are William Earl Storch?
Yes, sir.
Mr. Storch, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3 on the amended information, receiving and concealing stolen property of $200 or more, but less than $1,000?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a fine that is the greater of $2,000 or 3 times the value of the property?
Yes, sir.
Is it also your intention to plead guilty today to count 4 on the amended information, illegal entry without the owner's permission?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 90 days in jail and or a $500 fine?
Yes, sir.
Are you satisfied with Mr. Dagger Margosian and the advice that he's giving you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Dagger Margosian?
Yes, other than what was put on record, Your Honor.
Is that also your understanding, Mr. Storch?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up any rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Storch, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
And you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about October 7, 2020 in Fairfield Township, Lenawee County, Michigan, that you did commit the offense of receiving and concealing stolen property of $200 or more, but less than $1,000?
Yes, sir.
If you want to plead guilty, I need you to say guilty.
Yes, sir. I'm guilty.
And how do you wish to plead to the charge that on or about October 7, 2020 in Fairfield Township, Lenawee County, Michigan, that you did commit the offense of illegal entry without owner's permission?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the board on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or other or inducements other than the plea bargain to induce Mr. Storch to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Storch, has your attorney promised you any particular sentence or estimated what your sentence would be other than as it's been discussed on the record today?
No, sir.
Is it your own choice to plead guilty?
Yes, sir.
Mr. Dagger Margosian, do you want to establish a factual basis?
Mr. Storch, on October 7th of 2020, as the court indicated, were you in Fairfield Township in County of Lenawee, State of Michigan?
Yes, I actually admitted it.
Is that a yes?
Yeah.
Okay. And on that date and time, did you come into possession of stolen items, specifically some pistols and currency? I'm sorry, I didn't hear the answer.
Mr. Storch, it sounds like you're in a bad cell. You need to move to a spot where you have better reception.
Sorry.
All right, so Mr. Storch, on that date and time, you came into possession of some pistols and U.S. currency?
Yes.
It's still
we're not able to understand what you're saying, Mr. Storch. You need to find a spot where you have better reception.
Yes.
Okay. And you knew those items to be stolen?
No, I was not aware.
All right, but you had no reason to believe that they were lawfully possessed?
No, I thought they had owned them. So.
Judge, can I have a breakout room with Mr. Storch, or, I mean, we have to have a factual basis here, so.
I will put you in a breakout session so you can speak to him.
Okay.
All right, while that's happening, let me call Mr. Kennedy's case. So we're on the record in file 23-21426-FH, 23-21427-FH, 23-21578-FH, and 24-21803-FH. People versus Daniel Martez Kennedy. We are here today for a pretrial conference in those cases, and we're proceeding by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.B. McClure, on behalf of the people.
Paris Hennigan on behalf of Mr. Kennedy.
All right, and,
Your
oh,
Honor,
I'm sorry.
I have one of the files as well. If you called it, is it 242-1803?
Yes, I did call that one. I apologize. And that is set for arraignment today.
Yeah, I
not-
represent Mr. Kennedy on that file, Your Honor.
Okay, so let me do the arraignment portion of it first. Mr. Glazier, does Mr. Kennedy wish to have that information read?
No, we'd waive the reading of the information, Your Honor, and a plea of not guilty, and ask the matter be set for a pretrial. I believe Ms. Hennigan's going to ask for a pretrial on the other one so that we can resolve it all together.
Okay, so we'll enter a not guilty plea for Mr. Kennedy on the 24-21083 case. And I apologize. Looks like no, never mind. And then Ms. Hennigan, is that accurate that you were going to ask for an adjournment of the pretrial on the other cases that you represent Mr. Kennedy on?
Yes, Your Honor, this case was almost resolved and then was reassigned to a new prosecutor. Mr. Fleming left, and right before he left, the original offer was withdrawn. So I do not have a current offer for Mr. Kennedy. So we'd like to set this out for a pretrial so that both Mr. Glazier and I can have a chance to talk to the prosecutor that's assigned now.
And Judge, may I
Alright.
speak to that?
I'm sorry, go ahead.
Yeah, so the prosecutor of record is Isaac Sneed, but I do know that the prior offer was withdrawn only because of the new charges. At this point, that offer was reinstated, and the new offer is what the last agreement was on the 3 felonies with Miss Finnegan. And on the new case, it was to plead to 2 new felonies that would be sentenced concurrent with, I think it's 42 months on the other files. So I don't know if that helps at all for now, and then you can continue to speak with Mr. Sneed about it, but just so we know there is something out there, so Mr. Kennedy can start considering it, and obviously you can talk with Mr. Sneed further.
So Isaac has all the files.
Correct.
All right.
Thank you very much, Ms. McClure. If you could just pass it on to Mr. Sneed to resend that to me so that I'll have it as a current plea agreement, and then I'll go over to the jail and talk to Mr. Kennedy about it.
I can do that.
Thank you.
Okay, let's set these for pretrials then on May 22nd at 8:15. And Ms. Hennigan, would you do stipulation and orders for your cases?
Yes, Your Honor. You don't want me to include all of them and then just put all the attorneys on?
No, we'll do a notice on the arraignment file.
Okay, thank you.
And just for the record, Mr. Kennedy, I believe, stepped out when he heard what the next date was.
And I'm sorry, what is that next date?
May 22nd.
Okay, thank you.
Thank you, Your Honor.
All right, thank you. Okay, Mr. Glazier, we I think we're ready to proceed. Oh, let me get back to finish Mr. Stork's case. So back on the record in file 24-21797-FH. Mr. Dagger Margosian, where do we stand with Mr. Stork's case today?
Your Honor, I did clarify a few things with Mr. Storch. We are still ready to proceed with the plea taking. If I can just continue with the voir dire.
All right, if you want to resume with that, you can go ahead.
Mr. Storch, just so we're clear, again, the date was October 7th of 2020. You were in Fairfield Township, County of Lenawee, State of Michigan.
Yes, sir.
All right, and on that date, did you received some items, specifically they were pistols and currency
Yes.
And you knew that those items were stolen at the time of when you received them.
Correct.
And the amount, the value of those items would be between 200 and 1,000.
Yes, sir.
All right. And you entered a pole barn at the location listed on the information.
Yes, sir.
And you did not have permission to enter that pole barn at the time of when you entered?
No, sir.
Okay. I am satisfied, Your Honor.
Excuse me.
I'm satisfied with the factual basis.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. Moore?
It has.
Mr. Dagger-Margosi?
Yes, Your Honor.
All right, I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Storch had full knowledge of his rights to have competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defendant, defense attorney, or anyone acting in the interest of any of them. I will refer this matter to the probation department and will set sentencing for June 13th at 8:15 a.m.
All right, thank you.
Your Honor, is that on Zoom or in person?
That can be by Zoom if Mr. Storch prefers. Mr. Storch, you do have a right to be present in the courtroom for the sentencing if you want to be. But if you want to waive that right and do it by Zoom, you're welcome to do that as well.
It's actually easier for me to do Zoom, so being I don't have transportation.
All right, if you're going to do it by Zoom, you need to be somewhere where your connection is good and we're able to hear you. It's got to be someplace that's a little better than today because we're having difficulty today.
All right, I apologize. I couldn't afford to take no time off.
If that restitution is not paid, I would just ask that he appear in person to pay on that day or receive a sentence in accordance with that. Because the agreement is for restitution to be honored before sentencing. So if it's not paid prior to that sentence date, I would just ask that he be here in person.
All right, so if you haven't paid the restitution by the sentencing date, then Mr. Storch, you need to be here for sentencing in person.
Okay.
All right, I'm going to put you, Mr. Storch, in a breakout room with Mr. Moore from the probation department. He's going to collect your contact information and give you some instructions.
Your Honor, isn't this a misdemeanor?
Oh, I'm sorry. Thank you. These are both misdemeanors. So, Mr. Storch, what you're going to need to do is report to the district court probation office at the courthouse on the first floor this coming Tuesday at 8 a.m.
Well, that's the one by the records office, sheriff's office, right?
It's in the courthouse. The newer courthouse on the first floor. So the big, tall, brown, plain looking building, not the fancy looking one.
One over by Bellstone?
It's the.
I'm sorry?
If I may.
Go
ahead.
From Bellstone?
Mr. Storch, it's the building where we had our first court hearings in district court.
Okay.
All right.
All right. You're all set then, Mr. Storch. You can go ahead and log out.
All right.
Okay. All right. Let's go to Mr. Silvertooth's case then. So we are on the record in file 23-21612-FC, People versus Kenyatta Taiwan Silvertooth. We are here today for, again, this is a final pretrial as well as a hearing on a motion, defense motion to sever joint trial. We are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
John Glazier and Mr. Margosian, we're on behalf of Mr. Silvertooth, Your Honor.
All right. Other than this issue of severing the trial, are there any other issues we need to address today?
No, Your Honor. I just, can I speak or did you want me to wait?
No, go ahead.
Your Honor, I think we were prepared just to do this as a joint trial, but I didn't hear a lot of, I was over in the other court, so I didn't hear what you and Mr. Daly were discussing about a proffer. We need to see what that is. I guess if the prosecutor assures us that that's not going to be used in evidence at the trial in any way, we probably still would agree to consolidate, but I got to see what the proffer is and have some assurance that my client, or if Mr. Winsett takes a stand, that he's not going to be, that's not going to come in evidence be used against him. I don't know what the proffer says at this point. I've not been given a copy of it.
All right, Ms. McClure, is there anything you want to address with respect to that issue?
I don't want to misrepresent to the court what that proffer is. The only thing I can say is that's something Ms. Wise handled. So it might be better addressed with her. But at this time, my understanding is there was a proffer agreement signed, but no statement actually given. So there is not a current proffer. I have not received any further information that Mr. Winsett is going to testify. But if he is, then obviously we would go forward with a statement at that time. But as of this time, I don't believe there is a statement, and I don't believe Mr. Winsett is intending to testify.
I guess I don't understand if there's something written and signed. I mean, that sounds like something I should be able to see, but
if there's no statement to give, I mean, then I don't have anything to give. But again, that is something Ms. Wise handled. So
I guess my question is, what are you saying that you have that is signed?
Your Honor, I can clear that up if the court would like me to.
Okay, so we have Mr. Daly here who represents Mr. Winsett. So he's offered to provide some clarification on whatever this is that we're talking about. So Mr. Daly, if you want to try to do that, please go
Your Honor, about a month ago, there was an opportunity that we had to make a proper statement. We met with the prosecutor, the detectives involved, and we're in the process of making a proper statement, which was video recorded at the time. The entire process broke down. We did not continue with that statement. There is a recording of that statement. I don't have that recording, but there is a statement there. And in our file, we have the regular disclaimer that goes along with the proffer about when it can be used and when it can't be used. That's been shared with Mr. Winstead, as I indicated earlier. Whether Mr. Winstead testifies or not, I really don't know. The trial hasn't started yet. Same with Mr. Silvertooth. If there is a joint trial, that's an issue that always comes up in a joint trial. You can't predict things ahead of time, but I'm fine with the joint trial. I'm fine with going ahead. I'll talk to Mr. Glazer about what Mr. Winstead said in the proffer whenever he wants to, but there is no recording of that that has been released. As I told Mr. Winstead, if he gets on the stands and tries to say something different than he made in a recorded statement, I assured him that he would be cross-examined on that by the prosecution. But as far as there being a done deal or anything like that, there is not. Mr. Winstead has been offered nothing that he wanted to accept, and we are prepared to go to trial. I don't believe there's anything more to the proffer agreement than that. And there is no record of it. I don't have a record of it. And I was there for it, but I heard it.
All right, Mr. Glazier, anything else you want to say about the issue at this point?
Yeah, yes, Your Honor. And here's my problem. I would like to have a copy. First, Mr. Daly said it was recorded, and then at the end, he said it wasn't recorded. If it is recorded, I would like to have a copy of that proffer. If it's not recorded, I need to know what the prosecutor may impeach Mr. Winsett in the case before I can agree to be consolidated with it. And I can't do that until I see, I mean, Mr. Daly's client could take the stand. They could impeach him with a bunch of statements that he made outside the courtroom would be against my client's interest. And it's not just impeachment. Now it's being used, or it's being heard by the jury in my client's case. And I can't agree to a consolidation until I know what his client may be impeached with if he takes the stand. And somebody has to know what those are. And I don't know, Mr. Daly, I don't know if he noticed he said it was recorded, then at the end he said it wasn't recorded.
It was recorded. I didn't mean to say it wasn't.
Okay, if I have a copy of that, I can make a decision. Or if I get an assurance from the prosecutor that they're not going to impeach him with it. That's those two things I would need. Otherwise, I can't consolidate.
All right, Ms. McClure, is there anything further that you would like to say on the issue?
Just briefly, that one, I'm not sure about the discoverability of any recording. That is something I would like time to look into. I think if it was discoverable, though, Ms. Wise would have provided by now. And two, I think we're kind of creating more issues as it relates to consolidation, and we don't need Mr. Glazier to necessarily agree to it. There's been a motion, there's been an answer. I think at this point, it would be appropriate for the court to rule on that.
Well, the facts have changed significantly since the motion was filed and since even last week when we started to discuss this issue. So I don't think it's as simple as saying there's a motion filed and the motion needs to be ruled on. Here is the situation as I see it, that Mr. Winsett may or may not testify. There is apparently a statement he made which may or may not be entered into evidence or offered into evidence depending upon whether or not Mr. Winsett chooses to testify or not. We also have an issue of photographs that are potentially going to be offered into evidence under 404B of Mr. Winsett that would potentially create additional issues with respect to Mr. Silvertooth. As I see all of those issues and the potential problems that can arise from those issues, I think that they can all be addressed by having separate juries in one trial. That way, if there is photographic evidence that is appropriate to enter in Mr. Winsett's case, that is not appropriate to enter in Mr. Silvertooth's case, we can move one jury in and out as appropriate so that they hear the evidence that they should hear and see the evidence that they should see, and not hear and see the evidence that they should not hear and see. Given the number of questions that we have around these issues, at this point, I think that is the proper way to go. So my intention at this point with respect to the joint trial issue would be to conduct one trial with a jury for each defendant. So having said that, are there any further issues that we need to address?
I have no, Your Honor.
Nothing on
County-
behalf of the people.
All right, so Mr. Winsett, you can let the officer that's with you know that you are done with court for today.
Actually, Judge, there is one, I'm sorry, there is one thing. The
I'm
people,
sorry.
you did say Mr. Winsett, but I knew you meant
Yeah,
Mr.
sorry.
Silvertooth.
I
But-
apologize, Mr. Silvertooth. I called you by the wrong name.
The only other thing that had come up is the people filed a stipulated set of jury instructions and a verdict form. Mr. Daly has stipulated to that. Mr. Glazier has indicated he reviewed it, did not wish to stipulate to that at this time, but he knew we were filing that. So I just wanted to put that on the record that that's been filed and stipulated to by one counsel at this point.
Anything else from either defense counsel on the instruction and verdict form issue?
Your Honor, I guess my question is, when we talked about this last time, you indicated we're gonna, we're gonna wanna submit some jury instructions and maybe object to some after the proofs have gone in. But you had indicated that you were gonna read jury instructions prior to the jury hearing any of the evidence. And I guess we would have some objections to the instructions that are being proposed. We received them, I don't know when we received them. They were sent to us the 24th. I've gotten those and some voir dire questions, I think the start of this week. But we're not going to agree that those and I don't know if that's the court's intent, but we're not agreeing that those set of jury instructions should be read to the jury prior to any evidence being taken. And I don't know if
Well, I have preliminary jury instructions that I read at every trial.
Yes, we understand that. And I don't know if that means that you're going to read these as preliminary jury instructions. I probably have no objection to your normal preliminary jury instructions. And I guess if these are just intended to be at the end of the trial after the proofs, we can make objections to those depending on what the proof shows.
All right, I obviously understand that the final instructions need to be tailored to what happens at trial.
Sure.
What I'm concerned primarily about at this moment is resolving any issues that may arise with respect to the preliminary instructions so that we're not trying to hash that out at 9 a.m. on May 14th when the trial is supposed to begin. I want to come in on the day of trial and start the trial, not resolve evidentiary issues and voir dire questions and jury instructions issues. That's the entire point of having a final pretrial conference in my mind. So are there any issues with respect to the preliminary instructions?
I don't have the preliminary instructions. I have the stipulated jury instructions. Are those supposed to be preliminary jury instructions?
Yes, those would be the case specific ones. I don't file the.
Then yeah, we would object to
Court
those,
reads.
Your Honor. There's certain things like aiding and abetting and things of that sort that are being put into the preliminary jury instructions without any evidence of that nature. We don't have problems with your normal preliminary jury instructions.
I guess I don't understand the objection because
We do have a problem, I guess, with the prosecutors. If those are proposed preliminary jury instructions, yes, we have objection to those. We're not stipulating to them.
All right, so what instructions in the preliminary instructions are you objecting to?
I don't have your preliminary jury instructions, Your Honor.
Which instructions of the ones that the prosecution filed are you objecting to?
We would object to Aiding and abetting, we would object to aiding and abetting a felony firearm. We would object to inducement. We'd object to presence insufficient. We don't have any problem with first degree, second degree murder. I guess we'd have an objection to inferring state of mind. We'd have an objection to now degree of murder, I think is okay. We'd have an objection to discharging of, oh no, we'd be okay with that one. We'd have okay with the next one, possession. We'd have those are the ones we'd have main objections to. Oh, wait. Multiple counts. Other offenses, I guess we'd have objection to that. I think that'd be it. Those are final jury instructions. Those are preliminary jury instructions.
I don't want the argument on them now. I'm just trying to identify what ones are objected to so that we know when we have the argument which ones we're talking about.
All right, those are the ones. Do you need me to go over those again?
I believe I've got them all written down.
I don't know if Mr. Margosha, anything else, Mike, that you can think?
I agree with Mr. Glazier's assertion that all of those would be appropriate for post case in chief instructions and not prior to the trial starting.
All right, so I'll set a hearing on those objections for May 14th at 8 a.m. That's 1 hour before the trial starts.
Judge, are you going to require the defense to file a written objection with their reasons why they're objecting to those?
I think they've stated on the record here which ones they're objecting to. If they want to file a further brief on those, they can. If not, we'll just decide it on the oral argument.
Okay, thank you.
And obviously, if the people want to file a brief with respect to any issues, you're welcome to do that as well.
Okay, thank you.
All right, anything else we need to address with Mr. Silvertooth's case today?
The only other thing, Your Honor, was we got served after this. I think we got served 2 days ago. Let me see. Some voir dire questions. And we would certainly have some objections to those. I don't know if you want those ahead of time or not. We got this, I don't even have, oh, it's dated the 29th, so we would have got it 2 days ago. For people's proposed voir dire. Do we need to file those ahead of time, or do we bring that up at the same hearing?
We will address them at the same hearing.
A final thing, Your Honor, that I guess we ought to bring up at this point too as well, is there's going to be separate juries, and at some point, there's going to have to be a decision made on which witnesses both juries are going to hear and which ones only one jury will hear. Some of this 404B, we would probably want it to be heard by our jury as well. So I don't know when we bring that up. I assume during the trial before the witnesses are called, but I guess that's up to the court.
Well, to the extent those issues can be identified and resolved before the trial starts, that's obviously a better situation than trying to do it on the fly. So,
sure.
You know, I would encourage the attorneys involved to try to work through these issues and identify areas where there are going to be disputes about which jury should hear what testimony or see what evidence, and bring those to me as soon as they are identified so that I can attempt to resolve them again before the trial, not during the trial.
All right. That may be a work in progress also as the trial goes along, but we'll try, Your Honor.
All right. Anything else for today then?
No, Your Honor.
Ms. McClure?
No, Your Honor.
All right, Mr. Silvertooth, then you can let the officer that's with you know that you're done with court for today. And Ms. Underwood, give me just a second. I'll give you a breakout room with Mr. Brown. Mr. Glazer, did you find anything further out with respect to Mr. Clark?
Yeah, I had some bad notes written in there. I'm mixing it up with another case. I don't know why he's not here. I tried calling the number he gave us, and it was a friend of his. It wasn't actually his phone. He said he'd try to have Mr. Clark get a hold of me, but I haven't heard anything from him. That must have been an hour ago at least.
All right. Okay, so we're on record in file 24-21804-FH, People versus Larry Dean Clark. We are here today for an arraignment. For an arraignment in this case, we are proceeding today by video conference. Courtroom is also open to the public. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure, on behalf of the people.
John Glazer on behalf of Mr. Clark.
Okay, and the record should reflect this was set for an arraignment this morning at 8:15 a.m. It is now 11:17 a.m. Mr. Clark is not present here in the courtroom, nor is he logged into the Zoom session. I have identified all people that have logged into the Zoom session this morning, and Mr. Clark has never been present by Zoom. Mr. Glazer, is there anything you'd like to say with respect to Mr. Clark at this point?
Your Honor, just as I indicated before, and I guess that wasn't on the record, but I called the phone number in our file that Mr. Clark gave us. And when I called that, I got somebody who indicated he was Mr. Clark's friend. I told him that he was supposed to be in court this morning and hadn't showed up. He said he would get with Mr. Clark and have him call me on the phone number that I had used, and I'd used my office phone. We haven't heard anything from Mr. Clark, and I have no idea where he's at.
Ms. McClure, anything from the people's side?
Nothing to add.
All right, it appears that this is Mr. Clark's first failure to appear in this case, so I will wait 48 hours to see if we hear from Mr. Clark. If we don't hear from Mr. Clark within 48 hours, I will at that time revoke and forfeit his bond and issue a bench warrant for his arrest. And I would set bond on that bench warrant in the amount of $25,000 cash or surety. Okay, let's see. So
I think that's all I have with you this morning, Your Honor.
Yes, that's all I had for you, Mr. Glazier. Thank you.
All right, thank you. We'll see you later.
Mr. Dagger Margosian, have you spoken to Ms. Edwards?
Your Honor, I spoke with her yesterday. I can briefly tell you that we're still waiting on the preliminary exam transcript. And so I was just going to ask for an adjournment anyway. I don't know if you want to get the case called. I don't know if she's in the waiting room right now, but I did speak with her yesterday.
Okay, so let me call the case. She's not present, I don't believe. Excuse me. Yeah, neither of you are Ms. Edwards, correct?
No, we were here to watch a suspension done.
Oh, Mr. Fenton?
Yeah.
Yeah, that got, Mr. Lyons asked for an adjournment on that, and it got set over to May 22nd.
Is it in the morning?
Yes, we schedule everything for 8:15 and then just kind of call them as they get here. Mr. Lyons is usually pretty punctual, so he tends to get called pretty early in the call. Okay. All right, so we are on the record in file number 24-21766-FH, People versus Cateresa Pearl Edwards. Here today for a pretrial hearing this case and proceeding today by video conference. Courtroom is also open to the public. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of People.
Your Honor, Michael Dagger Margosian for Ms. Edwards.
All right, and record should reflect this was set for a pretrial this morning at 8:15 a.m. It's now 11:21 a.m. Ms. Edwards is not present. There is no one here in the courtroom and there is no one in the Zoom waiting room. I have identified all people who have been in the Zoom waiting room this morning and none of them have been Ms. Edwards. Mr. Dagger Margosian, is there anything you would like to say with respect to that issue?
Well, Your Honor, the only thing I'll add is that I did indicate off record that Ms. Edwards and I spoke yesterday. I do plan on filing a motion to quash on this case. We have put in a request for the preliminary exam transcript. We don't have that transcript yet. So my intention today was to ask for an adjournment to get that. I guess what I would ask the court to do is adjourn the case and maybe issue a show cause for Ms. Edwards as to why she was not here today. Again, I did speak with her yesterday. But that's what I can relay to the court at this time. And obviously, if
go ahead.
If the court does follow that plan, and if she does not appear a second time around, it would be certainly a different circumstance.
Ms. McClure, anything you'd like to say from the people's side?
Just for clarification, is this the first pretrial post arraignment?
Sorry, I'm scrambling to find Ms. Edwards' file. I don't seem to have it.
It should be.
Yes, yes, it is.
And was the arraignment waived?
Yes, it was.
Okay. I guess I would be okay with the show cause then if the court is.
All right, so what I'll do is set this for a pretrial on May 22nd. And I am going to issue a show cause for that same date regarding her not appearing today. Anything else we need to address with that case, Mr. Dagger-Margosi?
No, Your Honor, thank you.
All right, Mr. Madrid, if you give me one moment, I'm going to put you in a breakout session with Mr. Malero.
Okay, sir.
Okay, Ms. Underwood, are you ready to proceed with Mr. Brown?
I am, Your Honor.
Judge, did the court get a copy of the signed plea agreement? We didn't email it. Miss Underwood emailed it, or we emailed it to the
Your Honor, it should be coming back to you. Mr. Brown signed it at the jail, and I instructed him to send it, to have it sent back to Judge Olshaver's court.
I don't have it.
I just sent it a couple minutes ago, Your Honor.
Okay.
Judge, I assume Miss Underwood spoke with Mr. Haglund, but I don't know if you want us to go off the record and call him, or confirm where it was sent.
Sergio, do you want to check with Francis and see if she's got anything? They usually fax stuff.
I will call the jail and see where it is, Your Honor.
Judge, I have
Give,
not.
give us just a second. Just give us just a second. I'm having Sergio check with Francis because the jail usually faxes things to us, so it might be sitting in the printer out there.
No, Judge, I have not received anything.
Okay. I'll check.
Got anything here?
He's checking on whether it's been faxed yet or not.
All right, Mr. Malero, are you ready to proceed with Mr. Madrid?
I am, Your Honor.
All right, we are on the record in files 22-20968-FH, 22-20969-FH, 22-20972-FH, and 24-21750-FH. These are set for pre-trials this morning, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Salvatore Malero on behalf of Michael Madrid.
All right, and Mr. Malero, where do we stand with Mr. Madrid's cases today?
Your Honor, I'm going to ask to adjourn the underlying case as well as the violations out perhaps 30 days. My schedule cleared up tomorrow. I'm going to go see Mr. Madrid. We're going to discuss whatever it is he needs to discuss, and then I'll meet with the prosecutor, see what, if any, resolution can be had in this matter. I think 30 days would probably be sufficient.
Ms. McClure, is there anything to address from the people's side?
Nothing to add, Your Honor.
Okay, let's go with June 5th at 8:15.
Okay.
All right, Mr. Madrid, you are all set with court for today.
Thank you.
Thank you, sir.
Thank you, Judge. I'll do the stip in order.
Okay, thank you, Mr. Malero. I'm just emailing for Mr. Paulding right now.
Thanks.
Judge, I think the last couple cases you have are with Miss Arnold, so I'm gonna go ahead and log out.
Okay.
Thank you.
Do you have a copy of the document, Ms. Underwood?
I'm sorry, Your Honor.
Do you have a copy of the document?
I signed one downstairs. The jail said they were faxing it over, Your Honor.
They haven't.
I talked to them right before
I called the jail, and the jail said that they're looking for it now to send it over.
So looking for it is not encouraging at all.
No.
Ms. Arnold, can you send me an unsigned copy so we can proceed and wait?
Judge, our office doesn't feel comfortable sending unsigned copies of an agreement because it's not an agreement until it's signed by both copies. I know I don't want to be pedantic about it, but we've been doing that, and we are concerned that it's not, we're sending up an agreement that's not an agreement. I do have the copy Miss Underwood signed down here, or I can bring up a copy if she wants to sign it on her own behalf and sign it with permission from him and then present it to the court. That would probably have been easiest. If I would have known it was taking so long, I would have just ran it around myself.
All right.
I don't understand where it is, Your Honor, because the jail told me not 5 minutes ago.
I have something coming right now.
All right. just for future reference, we've been at this for over an hour, and I will no longer do this on Wednesday mornings.
Okay.
If it requires a signed plea agreement to get a plea entered, that must be in the court's file by the Tuesday before the Wednesday hearing. If it's not, we're not going to go through this on a regular basis. I'm just going to adjourn the pretrial and deal with it another day, because I can't use up this much time trying to work through these issues on a Wednesday morning.
I understand, Your Honor, and it won't happen again. This is the first time this has been required, and
All right, so I have the signed plea agreement now. Appears to have been signed by Mr. Brown and by both Ms. Underwood and Ms. Arnold. So we can go back on the record for Mr. Brown's cases. Again, these are 23-21572-FH, 23-21573-FH, 23-21667-FH, and 24-21735-FH. Okay, so I do have the signed plea agreement at this point. Ms. Arnold, do you want to review that for the record, and then I'll ask Ms. Underwood to confirm?
Certainly, Your Honor. Under the agreement, the defendant is charged with the crimes listed on the felony information dated February 22nd, 2024 for file 2421735-FH, January 8th, 2024 for file 2321667-FH, and October 17th, 2023 for files 2321573-FH and 2321572-FH. The defendant agrees to plead guilty to the following crimes. Count 1 in file 2421735-FH without subs, as charged in file 2321667-FH without subs. To count 2 in file 2321573-FH without subs, and count 2 in file 2321572-FH without subs. There's a sentence agreement between the parties to 1 year of immediate incarceration in jail, followed by a term of probation set by the court, and all sentences to run concurrently. The people will dismiss all other charges and supplements for the listed files, as well as dismiss pending to a district court file 232140 SM. Restitution as determined by the court on all counts in all above listed files, whether pleaded to or dismissed, including file 232140 SM, will be paid by the defendant. The defendant acknowledges one of the consequences of the crime is that entering allows the court the discretion to impose consecutive sentencings at the time of the sentencing, and the other standard terms of our plea form would apply.
All right, Ms. Underwood, is that a complete and accurate statement of the plea agreement?
that is a correct recitation of the plea agreement, Your Honor. I would just add that Mr. Brown is receiving credit for time served. I believe he's been in jail since December, Your Honor, as to that year.
And Judge, to expedite matters, it might be better if Ms. Underwood has no objection, I question Mr. Brown on the sex offender registration violations. I have some familiarity with those offenses and the elements, so it might make it quicker.
Sex offender.
I have the elements.
I know sex offender. What?
Mr. Brown, we're not talking to you. Kyle Brown, we're not talking to you. We have a different Mr. Brown with right now. So just hang on tight till I call your case.
All right.
All right, Mr. Bobby Brown, will you raise your right hand? Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Bobby G. Brown III, is that correct?
Yes. Yes.
Mr. Brown, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 24-21735-FH to count 1, failing to register as a sex offender?
Yes.
Is it your intention in file 23-21667-FH to plead guilty to count 1, assaulting, resisting, obstructing a police officer?
Yes.
And is it also your intention to plead guilty in that case to count 2, third-degree retail fraud?
Yes.
Do you understand the maximum possible penalty for the assaulting, resisting, obstructing a police officer charges up to 2 years in prison and or a $2,000 fine?
Yes.
Do you understand that the maximum possible sentence on the third-degree retail fraud is a 93 days in jail and or a fine of the greater of $500 or 3 times the value of the property stolen?
Yes.
Do you understand the maximum possible penalty with respect to the failing to register as a sex offender charge is up to 4 years in prison and or a $2,000 fine?
Yes.
Is it your intention in file 23-21573-FH to plead guilty to count 2, assaulting, resisting, obstructing a police officer?
Yes.
You can put your hand down, sir, if you want. And you understand that the maximum possible penalty for that offense is also up to 2 years in prison and or a $2,000 fine?
Yes, Your Honor.
And finally, in file 22-21572-FH, is it your intention to plead guilty to count 2, another count of failing to comply with reporting duties?
Yes.
I guess I said another count. It's not another count. That was different than the first one. But do you understand that maximum possible penalty for that offense is up to 2 years in prison?
Yes, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, Your Honor.
Do you wish to explain or challenge the accuracy or relevancy of any of the information? I'm sorry. Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we discussed on the record here today. Is that correct, Ms. Arnold?
That's correct, Your Honor.
Ms. Underwood?
Yes, Your Honor.
Mr. Brown, if a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Brown, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. You have any questions about any of those rights?
No, Your Honor.
And do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the file 24-21735-FH to the charge that on or about August 1st, 2022 through December 20th, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of sex offenders failing to register?
Guilty.
And in file 23-21667-FH, how do you wish to plead to the charge that on or about December 17, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of assaulting, resisting, obstructing a police officer?
Guilty.
And in that same file, again on December 17, 2023 in the city of Adrian, County of Lenawee, how do you want to plead to the charge that you did commit the offense of third-degree retail fraud?
Guilty.
And in file 23-21573-FH, how do you wish to plead to the charge that on or about September 29, 2023 in the city of Adrian, County of Lenawee, you did commit the offense of assaulting, resisting, obstructing a police officer?
Guilty.
And in file 23-21572-FH, how do you wish to plead to the charge that on or about January 1, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of sex offenders failing to comply with reporting duties?
I'm guilty of that also.
Has anyone made any threats or promises to you to induce you to plead guilty to any of those charges?
No, Your Honor.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that your pleas are given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Brown to plead guilty?
No, Your
No,
Honor.
Your Honor.
No, Your Honor.
Mr. Brown, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
All right, Ms. Underwood, do you want to cover the factual basis?
Yes. Mr. Brown,
Yes.
as a result of past convictions, you are required to be on the SORA registration. Is that correct?
Yes, Your Honor. I mean, yes, ma'am. Sorry.
And the SORA registration has certain requirements, correct?
Correct.
Back on between the dates of, I'm sorry, this is the 24 file, Your Honor. Back on between the dates of August 1st, 2022 and December 20th, 2023, did you fail to report a change of domicile? Were you in the city of Adrian, County of Lenawee, State of Michigan?
Yes.
And did you fail to report a change of domicile to the sex offender registration?
Yes.
And you knew that was a requirement?
Yes.
And you didn't do it?
Yes.
I believe the facts have been established.
All right, so this is on the 24 file. Ms. Arnold, are people satisfied with factual basis in that?
We are, Your Honor.
All right.
Which file did you want to do next? Yeah. Why don't we go to the 667 file? Mr. Brown, on December 17th, 2023, were you in the city of Adrian, County of Lenawee.
Yes.
And did you come into contact with an Officer Rose Nieto?
Yes.
And she is an officer of the Adrian Police Department, is that correct?
Yes.
And you knew she was a police officer?
Yes.
And she was conducting her lawful duty, correct?
Yes.
And she pulled over. She was investigating a retail fraud, and she pulled over and she asked you to stop. And you ran, is that correct?
Correct.
I believe the facts of the resisting have been established, Your Honor. And the reason you ran, Mr. Brown, was you had been in family fleet and home, correct?
Correct.
Family farm and home, I apologize. And you had taken a jacket from there, correct?
Correct.
And you left with the jacket.
Correct.
And it was for sale in that store, correct?
Correct.
And you didn't pay for it.
Correct.
You had no intention of paying for it.
Correct.
I believe the facts of 667 have been established in full, Your Honor.
Judge, I would just inquire that the jacket was offered for sale at a price less than $200.
Do you agree with that, Mr. Brown?
Yes.
We're satisfied.
Asked to file the 7-2 file, Your Honor. Mr. Brown, continuing on your requirements of the Sex Offender Registration Act, on January 1st, 2023, were you in the city of Adrian, County of Lenawee, state of Michigan?
Yes.
And it is a requirement of the Sex Offender Registration Act that you verify your address with the police on that date. It was a requirement, correct?
Correct.
And you failed to do so, correct?
Correct.
Your Honor, I believe the facts have been established as to that.
Ms. Arnold, is satisfied with the factual basis?
I am.
As to the 73 file, Your Honor, Mr. Brown, on September 29, 2023, were you in the city of Adrian, County of Lenawee, state of Michigan?
Correct.
And at that time, did you come in contact with Officer William White of the Adrian Police Department?
Correct.
And you knew Mr. White was an officer of the Adrian Police Department?
Correct.
And Mr. White was trying to arrest you on a warrant, correct?
Correct.
So he was engaged in his lawful duty, correct?
Correct.
And you resisted Mr. White by tensing up and pulling your arm away. Is that correct?
Correct.
I believe the facts have been established for all counts, Your Honor.
Ms. Arnold?
We're satisfied.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. Arnold?
Yes, Your Honor.
Ms. Underwood?
It has, Your Honor.
All right. I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Brown has had full knowledge of his rights. He's had competent counsel. The court's not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. We'll refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 13th at 8:15 a.m.
Is that June 13th, Your Honor?
Correct. Mr. Brown, someone from the probation department will be in touch with you to do a pre-sentence investigation and interview. When you do your interview, please be truthful about this offense or these offenses and about your background.
Okay.
All right, you can let the officer with you know that you're done with court for today.
All right, thank you.
Okay, so Ms. Underwood, do you need to speak to Kyle Brown?
I will go down to my.
Okay, so Kyle Brown, Ms. Underwood's going to log in on her device to have a breakout session with you. Yeah. Okay, Mr. Malero, are you ready to proceed with Mr. Pullman?
I am, Your Honor.
All right, we are on the record then in files 23-21449-FH and 23-21326-FH, People versus Bush Lee Paulding. We are here today for pretrial conferences in both of those cases, and we're proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Salvatore Malero on behalf of Bush Paulding.
And Mr. Malero, where do we stand with Mr. Paulding's cases today?
I'm going to ask for a short adjournment on this matter. The basis for my request is the prosecutor yesterday, I think it was, provided me with a written plea offer, and there are other matters I wish to review, but I don't think more than a week or two is necessary to figure those things out. So that is the reason for my request, Judge.
Ms. Arnold, is there anything to address from the legal side?
No, thank you, Your Honor.
I'm sorry, you said 2 weeks, Mr. Malero?
Yeah, no longer if the court can work it out.
All right, let's go with May. Yeah, I've got to go with 3. Let's go with May 22nd at 8:15.
All right, Judge, thank you.
All right, Mr. I'm sorry?
So I'll do the necessary paperwork, Judge.
Okay, thank you very much.
Thank you, Your Honor.
All right, Mr. Paulding, you can let the officer with you know that you are done with court for today.
Okay, thank you.
Your Honor, does you have anything further? May I be released?
Yeah, we are all set. Thank you.
Thank you, Judge.
Okay, and Ms. Arnold, I think the only other one is a probation violation, so.
All right, very good. I knew that was it for me, and I didn't know if you needed us on the last one, so I'll log out. Have a great day, Judge, and everyone.
Thank you.
Bye.
Neither of them showed up for it. Okay. She's probably new, Mr. I'm just going to Francis re-notice it before.
I don't know if you saw the email, we're doing some of the forgot for it.
Did see.
Motion.
All right, we are on the record in file 20-20030-FH, People versus Kyle Brown. We are here today for a hearing on an alleged probation violation. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Brown this morning, Your Honor. Thank you.
And where do we stand with Mr. Brown's case today, Ms. Underwood?
Mr. Brown has, I believe, a hearing tomorrow in district court on files that are down there, Your Honor. We would ask the court to grant a week's adjournment, Your Honor, to see what happens with those. Also, Your Honor, I don't know if the court or Mr. Moore would consider this. Mr. Brown, grandmother has passed away, and he's finding it very hard to get information about services and for her and stuff. I wonder if the court might consider a tether or some situation for Mr. Brown where he could have a reasonable bond in this matter, Your Honor.
My grandfather.
It's grandfather. I'm sorry, Mr. Brown.
Mr. Moore, do you have any thoughts about a tether?
Well, Your Honor, when Mr. Brown absconded, I went to that residence several times. The family members helped conceal him. And so if that's where he's tethering, it's not really a residence that I really would approve any longer. If you would like to require at a minimum a tether, then you know that would be okay. But you know, he's been gone and no, not complying, but at a minimum a tether.
What is your grandfather's name, Mr. Brown?
Michael Belknap.
Where did he live, here in Adrian?
No, he lived in Hudson. It's that address. It's at that address, 222 North Market. When I was pulled over, that's the only reason why I was behind the wheel. We were driving up to Jackson. He was supposed to be getting transferred the next day up to, I believe, Beaumont Hospital up in up by Detroit somewhere, and it didn't look good. So my grandma wanted me to drive her up there, up to Jackson, so that she could see him, because like there was nobody else really who could drive her that far. She's not capable of making the drive, or wasn't capable of making the drive. He had a collapsed lung, an infection in his bloodstream, and then he has a mass that was pushing on his heart, and it just something had happened. She wanted me. She texted me emergency, need a ride, and like I don't really know much. Like they were going up there to figure out more. None of them have money to answer the phone. I believe they're not looking very good at all.
So he's in a hospital in Jackson?
Last I knew on Saturday, but it didn't look like he was going to be making it very much past that.
Mr. Brown.
So, okay.
So I'm just a little confused. I thought you said he passed away.
I'm confused too.
Sound like
you told me, Mr. Brown, that he passed away.
Yeah, like that's what I got. Like, I really don't believe so. Like, I haven't talked to nobody. Nobody like has phone numbers for me to call on that side of the family. I'm hearing from my mom. It wasn't sounding good. The last they knew, it was touch and go basis, hour to hour.
Well,
and I mean, it's been a few days since I talked to anybody since Saturday, so I'm believing there's a funeral to go to.
How do you spell Dunlop? Is it D-U-N-L-O-P?
Spell that B-E-L-K-N-A-P-P.
B-E-K-N-A-P-P?
B-E-L-K-N-A-P-P. I haven't got to talk to anybody on this one.
All right, here's what I'll be willing to do. If I can find some information that he has passed away and that there is a funeral, then I will release you on a tether on the day of the funeral. I have not been able to find anything just Googling at the moment, but I will, I'll make an effort to see if we can find that information out, but I can't just, I can't under the circumstances just simply release. So again, if I can find funeral information, I'll release him for a period of time on the day of the funeral.
Yes, Your Honor.
Mr. Brown.
Or if you, Mr. Brown, find out that information, tell the jail to call the court and give that to me, and I can get it that way.
Mr. Brown, is there someone I can call?
I don't know their numbers. I can get a number. I don't know anybody's number on that side of the family, really. Like it's.
Well, I
haven't had a reliable phone. I use Facebook. I mean, Facebook's ruling the world, kind of.
Who's Facebook?
Janet Belknap.
How do you spell that last name?
B-E-L-K-N-A-P-P. That'd be my grandmother's.
I'm sorry. Say the spelling again.
B-E-L
K-A-L
B-E-L-K-N-A-P-P. Belknap.
I just sent it in the chat, Rhonda.
Thank you, Your Honor. Thank you, Your Honor.
All right, I'm not here next week, so it'll have to be May 15th.
Thank you, Your Honor.
So, Mr. Brown, you can let the officer with you know that you are done with court for today. Yeah, Ms. Underwood, thank you. Mr. Moore, thank you.
I believe.
Thank you.
I'm
Have a good
done
day.
this morning.